What? What is up, guys? Let's do this. Come on in. What? What? What is up, guys? Let's do this. Who really killed Brian Drake? Here's Jenny. You guys gotta like that cover right there. I kind of like it. The obvious suspect, baby. Who really killed Brian Drake? Here's Jenny. Get your Here's Jenny hoodie. Hello, moderators. Hello, members, subscribers. Do we know what the term summary judgment means? Well, summary judgment is when you put together a motion in which you are doing. So Jennifer Drake is the plaintiff in this case, and she filed a plaintiff's motion for the summary judgment on defendants' counterclaims because Jennifer sued the Moores for wrongful death. And then the Moores answered Jennifer's complaint, but then countersued and sued Jennifer. Okay. So what this case is we have, there's basically two cases going on at the same time. It's not just the Moores are defending the claims of Jennifer. It's now you have Jennifer defending the claims against what the Moores put. All right. So there's a civil procedure, just like there's a criminal procedure. And you get to the point of where you can ask for a summary judgment. Okay. And so basically what Jennifer did is she moved and she asked the courts pursuant to Idaho Rule of Civil Procedure 56 to enter summary judgment in the plaintiff's favor and dismiss all of defendants' counterclaims with prejudice, not just you could bring this back someday. Like with prejudice means you're never able to bring this back into the courtroom. Okay. So this motion is based, according to Jennifer Drake and her team, is based upon the files and records herein, plaintiff's memorandum in support of motion for summary judgment on defendants' counterclaims, plaintiff's statements of undisputed material facts, the declaration of Jennifer Drake, and the declaration of her attorney. Some facts. Jennifer Drake says, this is the introduction. Brian Drake was shot in the back and killed while sitting in his chiropractic office in Bonners Ferry. On March 12, 2020, defendant Daniel Moore confessed to killing Brian Drake in his interrogation by law enforcement on August 27, 2020, and was arrested for the murder of Brian Drake. The status of that criminal case is a remand from the Idaho Supreme Court containing the unanimous opinion that defendant's confession was voluntary and uncoerced. Jennifer Drake learned of the confession and arrest of defendant and additional evidence pointing to his culpability. Additional evidence. So she's claiming that not only do we have Dan Moore's confession, but there's additional evidence pointing to his guilt of killing my husband. She has expressed her opinion based upon what she learned from the investigation in the criminal case. So she's admitting that she learned things from the investigation of the criminal case. Even though he confessed to killing Brian Drake and his confession was voluntary and uncoerced, defendant has instead doubled down in this case, and made counterclaims against Jennifer Drake for defamation, tortious interference with prospective economy advantage, and intentional infliction of emotional distress. As will be demonstrated, all of defendants' counterclaims must be dismissed. So your summary judgment is you're going to come in here and you're going to say, listen, we're going to lay it all out here that we're going to continue just with my case, but what I'm asking you to do is dismiss the Moore's case against me because, and we're about to find out why she's saying that there's no merit here. We can't go forward with this because of X, Y, and Z. Well, let's see what's up. According to Jennifer, these are the factual and procedural history. So, plaintiffs filed their verified complaint alleging causes of action for wrongful death, negligent infliction of emotional distress, intentional infliction of emotional distress, and tortious interference with prospective economy or economic advantage on November 11th, 2020. So remember what I told you guys is the murder of Brian Drake was March of 2020. They do an investigation from March until August, where then they ultimately arrest Dan Moore at the end of August 27th. And then there's a preliminary hearing October 2nd. And after the preliminary hearing, Jennifer Drake, don't know when she hired her counsel, but whenever she did that, awesome. But she filed this civil suit, November 11th, 2020. November 11th, 2020. There was no shit. Dan Moore didn't even probably have discovery in his criminal case. He started off with 33 pages. And then right before the preliminary hearing, they data dumped him a week beforehand, had the preliminary hearing, and then about a month and a couple days, he gets hit with this civil suit. Now, defendant then, meaning Dan Moore and Jane Doe, because that's how they list the suit. Defendant then filed his verified answer. So he answered the complaint, and then he counterclaimed on December 9th, 2020, alleging 4 causes of action, 2 claims for defamation, tortious interference with prospective economic advantage, and intentional infliction of emotional distress. The defendant redacted the answer and counterclaim was filed on February 8th, 2021. You guys, this case was so crazy of what was alleged in these complaints that the answer to Jennifer Drake's and then the counter, the other side, meaning Jennifer Drake's side, they ran to the courts and were like, oh, you need to get this sealed. This needs to be sealed. This is crazy. All right. That's what Jennifer Drake and her team is saying. Like, wait a second. Holy shit. This is like, this was filed, not under seal. Boom. And if you got a hold of that filing within the first, however it was 7 to 10 days, you got that filing. After that, it was sealed and you couldn't get any more. All right. There was a handful of media outlets that got it, from my understanding. Now, you got to say, damn, what was in that filing? Well, we'll get to that. Standard for review. So for even the courts to consider this, there is a standard. And a motion for summary judgment is proper when the party bringing the motion proves that there is no genuine issue as to any material fact, and it is entitled to judgment as a matter of law. So this is Idaho Rules of Civil Procedure. Again, Rule 56. After the moving party has met this burden, the non-moving party then bears the burden to show the existence of a genuine issue of material fact. So with a summary judgment, you're trying to shift the burden of like, okay, well, we're going to list everything that no. You're going to have to like prove something right now before this goes any further. Again, this means that the non-moving party is required to come forward with specific facts establishing the necessity of a trial. So this was going to trial because Jennifer Drake brought a suit on. Now, when the Moores went ahead and countered, after they answered, they countered, which, by the way, I'm not an attorney, but if I was an attorney and if I was the Moores attorney back when this happened, I would have never countered. I would have only answered it and then stayed the motherfucker. You answer it and then stay it. What did Karen Reed just do? Did she sue Paul back? No. She got that motherfucker stayed. All right? It's exactly what I said was going to happen. She got it stayed. And I'll explain what that means if you don't know what that means. That means during a criminal case, okay, you have the right to remain silent. When there's a criminal case and a civil case parallel going at the same time, 99.9% of the time, you're going to be able to get that civil case to be stayed until the criminal case is handled. Okay. And when I say handle, that means come to a conclusion. In this case, the Moore Drake case, it was countered, it was answered, and then a counterclaim. And then the case was stayed right after 2021, going in after the new year. It was stayed because Judge Buchanan said, this is going to be at a stay. It was asked to be at a stay. And that means nothing is going to move on this civil case until there is a conclusion to this criminal case. So everybody could understand that. The movement will be entitled to judgment when the non-moving party fails to make a showing sufficient to establish the existence of an essential element of its claim and on which it bears the burden of proof. So here we go. To withstand a motion for summary judgment, the opposing party's case cannot rest on mere speculation. Flimsy or transparent contentions Theories, questions of fact, which are not genuine, or disputes as to matters of form do not create genuine issues, which will preclude summary judgment. Neither is a mere pleading allegation sufficient to create a genuine issue as against affidavits and other evidentiary materials, which show the allegation to be false. So it is well settled that a mere salient of the evidence or only a slight doubt as to the facts is insufficient to withstand summary judgment. The party opposing the motion must present evidence by way of affidavit or deposition to contradict the assertions of the moving party. Affidavits supporting or opposing the motion must contain facts which would be admissible at trial. And the trial court only considers the material which is admissible and bases upon personal knowledge. Summary judgment is properly issued when the non-moving party bearing the burden of proof fails to make a showing sufficient to establish the existence of an element essential to that party's case. So now we're going to find out what the argument is here. So again, summary judgment. Jennifer Drake's like, here we go. Argument A. Defendant cannot prove essential elements of his defamation claims. So remember, Dan Moore's accusing Jennifer Drake of defamation. All right. And the claims should be dismissed. Well, to succeed on each claim of defamation, Dan Moore, the defendant here, and Jane Doe must prove 6 elements. Element number 1, Jennifer Drake communicated information concerning defendant to others. Number 1. So, did Jennifer Drake communicate information concerning defendant to others? Can you check that off? Well, I can check that off. Yes. She came out and told the world on March 23rd, 2023, that they know who did it. They just need more evidence. Okay. She said things like, oh my God, he's back to work. He's, I can't believe he's working when he got bail and all this shit. So did Jennifer Drake communicate information concerning defendant to others? I believe that Jennifer Drake did communicate it. Number 2, the information impunged the honesty, integrity, virtue, or reputation of the defendant. Well, she's telling everybody that he's a murderer, right? That we know who did it, right? I mean, come on. So did the information, though, you can't just say, oh, Dan Moore went to the movies last night. The fuck? No. So the information impunged the honesty, integrity, virtue of reputation of defendant. Did it impugn it? Or exposed him to public hatred, contempt, ridicule. Do you think that Dan Moore has suffered any of these things I just said because of Jennifer Drake? So again, number 1, number 2, now you get to number 3. Number 3. So all of those things was the information either fucked with the honesty, integrity, virtue of reputation of defendant, or exposed him to public hatred, contempt, or ridicule. If you don't think Dan Moore is hated in Bonners Ferry and they think that a murderer is walking around free and he could practice his chiropractic work. Now here's number 3. The information was false. So now, was anything and everything that Jennifer Drake, anything that she said, false? Well, if Jennifer Drake knows who the killer is, don't you think what she said is false? If Jennifer Drake is the killer, isn't what she said false? If you know something to be true, okay, or false, and you say the opposite, that is the definition of defamation. When you know something not to be true, and you're saying something that is opposite of that. So for me with that, it's interesting because it's like the information was false. Well, I would think that if Jennifer Drake knows who the killer is, or is the killer herself, right? And has alluded in her private Facebook group that Dan Moore is the killer, I would say that that's false. But hold on. So that's number 3. Now, number 4 is Jennifer Drake knew it was false or reasonably should have known that it was false. So the information was false and Jennifer Drake knew it was false or reasonably should have known that it was false. And defendant suffered actual injury because of the defamation. And the amount of damages defendant suffered. So all of those check, they all have to be checked. Okay, in order to meet the elements of A, which is the defendant cannot prove, or I'm sorry, the elements of defamation. So you guys can ask yourselves what you think. So do you think that all of those Dan Moore and Jane Doe can prove? Defendant cannot prove, this is the argument. Defendant cannot prove all essential elements of defamation to a jury because he does not have admissible evidence that the information communicated by Jennifer Drake was false. That Jennifer Drake knew the information was false or reasonably should have known the information was false. That the information communicated by Jennifer Drake impugn the honesty, integrity, future reputation of defendant, or expose him to public hatred, contempt, ridicule, and that the defendant suffered an actual injury as a result of this defamation. Well, I'm not a lawyer, never claimed to be one, but I'm going to tell you what I think about number 1. Well, first we'll get to this. Hold on. Defendant claims that Jennifer Drake communicated the following opinions about him and updates about the criminal case and this case to others in a Facebook forum. Number 1, quote unquote, God answered our prayers. We have answers, end quote. Number 2, quote, there is a saying or a rule. There is always 2 sides to every story, but then there is always an exception to every rule. And this story is the exception to that rule. There is no other side to this story. This senselessness is just that. Senseless, period. Number 3, in quotes, no, there is no evidence pointing to someone else. Yes, there is plenty of evidence and it will all come out. You're damn right. It's all coming out. Yes, so far he is literally getting away with murder, but not forever. No, this is not over. Not by a long shot. Yes, I ask God why. The civil case will start and all that the defense is trying to hide will be brought to light because the civil laws do not protect the murderer like the criminal laws do. This is why we file civil suits. For when the criminal law fails us, I think that's fucking hilarious seeing that you filed before the criminal law had a chance to do a damn thing. Okay? When she filed November 11th, 2020, the criminal courts didn't throw out anything of Dan's at that point. You didn't give the criminal court any. If based on what you're saying, then you would have waited till the criminal courts failed you to file civilly. Or were you going to drop the claim once and if Dan was found guilty of the murder? Just pure fucking stupidity. What an oxymoron. This is why we file civil suits, for when the criminal laws fail us. That is not why you file civil suits. To the community of Bonners Ferry, no matter what quote unquote side you are on, no matter who you think did or didn't do this, you have a murderer walking in your midst. He is walking around a free man to do as he pleases. End quote. Number 4, in quotes, as Dan Moore is back at work in his chiropractic office, the galvanized spirit of law enforcement is working hard for this trial set for April 12th. This document tells the story. My prayer is that justice is served. Next one. In quotes, I know, and it is, I know, ... And it is public knowledge that the defense is trying to throw out the confession in court. End quote. Oh, for fuck's sake. Greed. Somebody asked her why he did it. Why did Dan do it? And she says greed. That's so unreal to me. Greed. Next point. In quotes, as you can read here, he confessed with details only he could know. That is all that should matter. I heard the confession. How did you hear the confession? Because I was in the courtroom for the preliminary hearing. Then you would have heard all the times he said, I want a lawyer. Then you would have heard what? That they told him what happened before he confessed. In my opinion, she says, oh, thank God, about time I heard, in my opinion, the judge's article does not represent what occurred that day at all, end quote. Jennifer was, in quotes, 100% certain that Moore killed her husband. Jennifer was looking for information in the hope of, quote unquote, bolstering her case against defendant. This is when she came out to the news, March 2023, and said that she was 100% certain that Moore killed her husband. Jennifer was just looking for information in the hopes of bolstering, we just need more. We need more evidence. We come forward. That's where I came into play. Okay. When Jennifer Drake reached out to the public for help, it's like, oh my God, this poor woman, I don't think that this doctor did it. Okay. So here, let's free a man and let's get this woman and her family the real perpetrator. I'm like, this is a great case because I believe that the law enforcement totally failed both families. And then I was just blown away by what I found. I didn't know that I was going to come in and that my amazing work would not be wanted by the prosecution, that my amazing work would not be wanted by the woman that's put a billboard up for $10,000 asking the public to come to help. Hey, oh my God, I would love to help. Let's help this widow, her children, and let's free an innocent man. Sounds like a great day. And last but not least, Jennifer made a claim that more information was needed to substantiate what they already know. End quote. Now, to be defamatory, the communication must be false in a material fashion. Well, I think that the phone, the cell phone, the call, the window, the autopsy sweater. But again, to be defamatory, the communication must be false in a material fashion. This means that the gist or sting of the communication, when taken in its entirety and in context, must be false. It is not sufficient to prove that some insignificant detail is false if the gist or the sting of the communication is otherwise true. So, We will be ringing the bell. We want to turn people into becoming members here. We're going to ring the bell. To determine whether a communication is defamatory, the statement must be read and construed as a whole. The words used are to be given their common and usually accepted meaning and are to be read and interpreted as they would be read and understood by the person to whom they are published. Well, how would you guys take this? Holy shit. I don't think I would take it any other way than Jennifer Drake is saying that Dan Moore is a murderer. Okay? How about you guys? Simply expressing one's opinion does not give rise to liability for defamation. Now, the question is was Jennifer Drake just giving her opinions? Woohoo! Everybody's going green. We got some gifted memberships. Cha-ching! Crystal, Amber, member for 7 months. We almost have a baby. Lana Braids, you are the best. Thank you so much. Appreciate that. Boom. And 10 gifted memberships as well as Moon. Woo. Green for the win. So, again, simply expressing one's opinion does not give rise to liability for defamation. So, none of the information Jennifer communicated, this is what her defense or her lawyers are saying, none of the information Jennifer communicated about defendant, the criminal case, or this case can be proven by defendant to be false. Hold my motherfucking beer. Hold my beer. That's why I've been working morning and night. Right there. None of the information Jennifer communicated about defendant, the criminal case, or this case can be proven by Dan Moore to be false. So you don't think that Dan Moore can prove false that he's not a murderer? You don't think that Dan Moore can prove that? I know for a fact he can prove it. And I know for a fact Jennifer Drake knows that Dan Moore is not a murderer. Defendant himself acknowledges that the information communicated by plaintiff was either her opinion or case updates. Case updates or her opinion. No, there is no evidence pointing to someone else. Yes, there is plenty of evidence, and it will all come out. Yes, so far he is literally getting away with murder, but not forever. You have a murderer walking in your midst. So my take on that is none of the information communicated about defendant, the criminal case, or this case can be proven by defendant to be false. Well, Jennifer Drake did a lot of the communicating to law enforcement on how everything went down, and that's the version of events that they took. I believe that I can prove that Jennifer Drake lied to the police right from the rip. For example, number one, the way her husband was shot and killed. He told me that he was shot through the window right before 7:26 p.m. Well, number two, that she didn't use her cell phone to call 911. Number three, the timeline of the crime is false entirely. And then that big question mark about that window. It is well established that the heart of the First Amendment is the recognition of the fundamental importance of the free flow of ideas and opinions on matter of public interest and concern. So this is of public interest, right? So we should have no problem having cameras in the courtroom. I believe Jennifer Drake's own statements when she says that Bonner's Ferry, you have a murder walking amongst you, you're making it very, very, the people have an interest in corruption. The people have an interest when you're saying that you have a murderer walking free. And Jennifer Drake says it herself that not only she deserves answers, but like Bonner's Ferry deserves answers. There is no such thing as a false idea, in quotes. A writer cannot be sued for simply expressing his opinion of another person, however unreasonable the opinion or how virtuous the expressing of it may be. Good to know. I'll cite that case. Thank you so much. All Jennifer has done, according to her attorneys, is expressed her opinion and communicated information she learned from the law enforcement officers who investigated the case and from court proceedings in this criminal matter. Jennifer's opinions and truthful statements made about true information are not false and thus cannot be defamatory. Jennifer Drake's true statements. Oh, I cannot wait for these bombs that I will not release ever. They're coming out in court. If you think I'm going to give all my tricks away, then you think that that I would be just as crazy as Jennifer. Oh God, I can't wait. Again, this is what her defense is saying. Like, this is what her lawyers are saying. What defendant's defamation claims are contingent upon is his argument that his confession to law enforcement was false and that the dismissal of the criminal charges somehow proves that his confession was false. I don't think that's what he's saying at all. At the heart of this argument is the message that Jennifer, the public, and this court should not believe the admissions made by defendant on August 27, 2020. And instead should now believe him when he says he was lying to law enforcement. Jennifer, however, continues to believe what defendant confessed to Assistant Chief Marty Ryan approximately 1 hour and 41 minutes from the start of the interrogation. I don't know what clock they're using for that. That's interesting. I want to hear more about this clock. She continues to believe that the defendant truthfully admitted that he did not go there to murder to him. It wasn't intentional. He couldn't even see inside. He had his blinds pulled. Where do you think that came from, Jennifer? Where do you think that came from? Verbatim, word for word. Where do you think that came from? How is that unknown to anybody? That only the, what'd you say? That only the person that killed him would know? She believes the number of other admissions which implicated defendant in Brian's murder. What other admissions? His denial that he could hear Brian talking on the phone, that he could see lights on in the office. Lights were on in both rooms, for the record. His indication that his intent was to scare Brian so that he would move on, that he didn't know how many rounds he fired, but guessed it was one. Every witness said there's 2 shots. Jennifer didn't even hear any shots on the phone with him, didn't hear glass break, nothing. That it was an accident, that he found out Brian was dead at 2 or 3 in the morning from Mick Millette, the Boundary County coroner, and that afterwards he threw the gun in the river. We have all those surveillance cameras. Why didn't law enforcement get those surveillance cameras from the morning to show Dan Moore driving down to the river? I'm just curious. Jennifer also believes the Supreme Court's unanimous holding that defendants' admissions to Assistant Chief Ryan were voluntary and uncoerced, and its recognition that the state has evidence which puts defendant at the scene of the crime. Woo-hoo! Yeah! At the scene of the crime. Can we just not put the cart before the horse? What time was the crime? 7:26? Then why would Isaac Funderburg's phone call to police happen before 7 o'clock? Why would, why would Jennifer Drake's cell phone not register any phone calls to Kootenai County Dispatch if she called 911 from being at home? Why does Kootenai County have no records of Jennifer Drake ever calling 911 there that day? And now, why would it be that Bonners Ferry's assistant police chief and others fudged with the CAD notes to cut, copy, and paste CAD notes like they did during the senior keg party night? Woo! Ow, that's going to sting. If you know, you know. This is insanity. Okie dokie. Jennifer Drake's opinion that the defendant murdered her husband is a direct result of defendant's confession to law enforcement on August 27, 2020. Merely because defendant now claims his voluntary and uncoerced confession was false does not make the information communicated by Jennifer Drake about what he said during his confession or what she learned from law enforcement and the subsequent criminal proceedings false. But what about what Jennifer Drake told police during the criminal investigation? What about what Jennifer Drake told police during her interviews? The lies. What about all that? So Jennifer Drake isn't repeating what law enforcement told her. Jennifer Drake is repeating what she told to law enforcement, right? Law enforcement just simply adopted Jennifer Drake's narrative of events on March 12, 2020. Correct me if I'm wrong. So she's not repeating what law enforcement told her. She's repeating what she told law enforcement on March 12, 2020. Let's just make sure we get that straight. What she told 911. So if you are providing false material to obstruct justice, that's a crime. These arguments, because I think that Jennifer Drake has actually really good attorneys. I'm fond of their work, actually. But I wonder when it becomes a point when you realize as an attorney, it's like the movie Primal Fear, when Richard Gere realized that Edward Norton was a fucking killer. Remember that? There is no stuttering. Come on. I wonder what it feels like for a defense attorney when that moment comes, or in this case, I guess you could say just attorney period. When you realize, holy fucking shit. Holy shit. Likewise, the false confession theory that defendant has peddled in the civil case does not provide any basis for concluding that Jennifer had any reason to believe when she communicated information that such information was false. Oh, fuck yeah. I love that last sentence was put in. Damn. But she did know it was false. That's the thing. Is that, so think about this. Listen to this sentence. Likewise, the false confession theory that the defendant is peddling here through the criminal or to the civil case does not provide any basis for concluding that Jennifer had any reason to believe when she was communicating what she was communicating, that she had any reason to believe that such information was false. Well, yes, she fucking did. That's where you're wrong. That's where you're wrong. And this attorney knows it, that if Brian Drake was killed before 7 o'clock right before that, then that would mean that Jennifer Drake knew from 7:17 to 7:26 when she was on the phone in Hayden with her husband, which there's no evidence of that, by the way. 2 phones communicating. It's going to be pretty problematic that, how the hell does the ambulance start staging and sitting close by a crime scene that they don't even know to exist yet? Why would ambulance be staging at Liberty at 7:37 and that you actually have to have law enforcement remove that out of the CAD notes? Because it looks awfully bad. That how could that be if the dispatch went out for medic after the staging? How does that work? Tisk tisk. So we have no records that Jennifer Drake ever called from her cell phone. We have no records that she was in Hayden. We have no cell towers showing the 911 call from Isaac Funderburg between the 7 and 8 o'clock time frame. Yeah. We have Eldora Gatchel and having 2 vehicles there. We have, what else? I mean, we have so much. But let's continue on. In addition to being unable to prove that false information about defendant was knowingly communicated by Jennifer, defendant also cannot establish that the information communicated by Jennifer fucked with his integrity, honesty, virtue of reputation of defendant, or exposed him to public hatred, contempt, or ridicule, or that he suffered actual injury because of the claimed defamation. As this court is aware, it is undisputed that defendant was arrested after he confessed to shooting Brian. It is also undisputed, that may be undisputed that he was arrested technically, but let's talk about when those search warrants were wrote up. Let's talk about those search warrants and when those were written up. Again, as this court is aware, it is undisputed that defendant was arrested after he confessed to shooting Brian. It is also undisputed that all of plaintiff's statements about him occurred after he was arrested and charged with second-degree murder. Well, I don't know if that would be necessarily undisputed. What if we can prove that Jennifer Drake did the Google search of Dan Moore in the web searches? What about that? I think it's definitely undisputed that it was Jennifer Drake breaking into Brian Drake's phone 48 hours before he was murdered. I don't think that looks like Dan Moore. So I think that's definitely undisputed. Undisputed, right? That Jennifer Drake right there is breaking into her own, trying to break into her own husband's cell phone with 5 different attempts, with 5 different passcodes, all going and just taking pics right there. That's undisputed. It wasn't Dan Moore trying to break into his phone and couldn't get in. It wasn't Dan Moore keeping pegs on him with Life 360. Her. Undisputed. This is why I think it's really important to sue the police. Because if what they're saying is we're going to just blame the police, hey, we got a lot of information from the police. If the police wouldn't have told us and said all these things, and we wouldn't have repeated them, right? Not if you can prove that it was likely that Jennifer Drake should have known that what she was claiming to be false. And that would mean if you had something to do with the murder. Again, what if the crime was not committed at 7:26 p.m.? As it's going to come out in trial that timeline is just completely fucking false in nature. False with proof. So what if the crime was not committed at 7:26 p.m. because it's corroborated by 3 eyewitnesses and their whereabouts and cameras from the local businesses in the area, as well as phone records. But also, who's Jennifer Drake's alibi witness? Who's Jennifer Drake's alibi witness? And quite frankly, it doesn't matter when the fuck Jennifer Drake made her statements. Jennifer Drake was pushing a narrative from the jump to go after a chiropractor for the murder of her husband for the purposes for financial gain. While the criminal case against defendant was dismissed pursuant to Idaho Code 19-815A, such dismissal is not an acquittal. A finding by a jury that defendant was not guilty and double jeopardy does not attach. The Supreme Court notably pointed out that nothing in its opinion prevents the state from refiling its complaint against Moore. That's the whole point about being something that's dismissed without prejudice. Without prejudice means that you can go refile these murder charges against Dr. Moore at any point in time. And whatever you're ever charged with, whether it be like theft or whatever, it's just the statute of limitations. And there is no statute of limitations on murder. But and that's why I brought up that this whole thing should still be stayed, for the record. Because the criminal case did not come to a conclusion. Because Dan Moore was never tried. But let's ask you a question here. Why haven't they refiled? Why haven't they refiled? If there's all this evidence, why didn't they refile? According to defendant, he used to be a pillar of the Bonners Ferry community, but quote unquote has been turned into a villain thanks in no small part to plaintiffs' continued press runs and allegations. Not only does he think he was a pillar of the community, but law enforcement actually said that about him. So when they were trying to say is, this doesn't make sense. We need to know the why. We don't know the why. Can you help us out? We have to figure out this why. It was after the arrest of Dan Moore. So you're admitting that you don't have a motive. You don't know why he shot and killed Brian Drake. And you're admitting that on camera. According to defendant admits, however, that his arrest for second-degree murder damaged his practice. Defendant also provided evidence to the court that he received anonymous threatening letters and was subjected to public ridicule and disdain among members of the Northern Idaho community, which he in no way connected to Jennifer or any information she communicated. Although defendant takes issue with the opinions, these are opinions. She went on the goddamn news and said, no, we know who did this. We just need more evidence. Okay, replay it. It's right there. But okay. Although defendant takes issue with the opinions Jennifer shared and considers such opinions to be defamatory, the law is clear that even an unreasonable opinion worthy of blame will not subject one to liability for defamation. Because it becomes no longer an opinion, you guys. If you can prove, and it not has to be beyond a reasonable doubt, it has to just be by the preponderance of the evidence that it is more likely than not that Jennifer Drake, Eldora Gatchel, and Caleb Cohen-Azara were involved in the murder and demise of her husband, then you win your defamation claim. You understand that? If you can prove that material facts that Jennifer Drake told the police were in fact false, she knew that they were false, she perpetuated that shit. And so is it truly that she is repeating what law enforcement told her, or is she repeating what she just told law enforcement and they fucking went with? They did no investigation. None. How did law enforcement eliminate Jennifer Drake as a suspect? How about that? Because I have yet to see it. Because once I have physical proof that I can deem through my own standards, unbelievable. Assuming that Jennifer's statements amount to facts, defendant cannot prove that false information was communicated, which, yeah. So let's see if this is what he's saying. Assuming, for argument's sake, argumento, assuming for argument's sake that Jennifer's statements amount to facts, defendant cannot prove that false information was communicated. The fuck we can't. Daddy. Which fucked with his honesty, integrity. You can't prove it. You cannot prove it. Well, you're right. We can't prove it. But you know who can? And you know what can? The criminal discovery. The criminal discovery. Without the criminal discovery and all of it, all the Brady material for Dr. Moore that was held back, the favorable material that was held back. But I think that there's still enough, because that's how bad, they didn't realize they didn't get everything out of what they didn't need to send or what they couldn't send to. And I caught it. I'll catch that stuff. But yeah, actually you can. So like he's saying, hey, for argument's sake, let's just go ahead and say that what she communicated is in her opinion, and she's stating it as fact. Okay. The defendant cannot prove that false information was communicated. And that's not true. I believe that Dan Moore can prove that. Again, the information communicated by Jennifer was what she learned from the law enforcement officers. And that is not true, guys. Again, the information communicated by Jennifer was what she learned from the law enforcement officers who investigated the case and from court proceedings in the criminal case. That's not true. Truthful statements made about true information may have had some influence on others, but as a matter of law, such statements are not defamation. Yeah, if they were fucking true. If they were true. So then what you sit there and you go through, and that's going to be my next episode, is let's talk about Jennifer Drake's every statement that she made to law enforcement. Finally, there is a complete lack of admissible evidence which establishes that defendant suffered any injury because of anything Jennifer Drake said. Indeed, in defendant's counterclaim, he does not even allege that he suffered any actual injury because of the alleged defamation. I mean, I don't know how you can fucking not be working, okay, and not have your practice anymore, and that people aren't coming to see you, because who wants to be worked on with a guy with his hands that committed murder? Nobody, right? What are you talking about? There's no... I think it's safe to say that if they had to move the fuck out of Bonner's Ferry... If Dan Moore is a victim of law enforcement building a case with false evidence, false bullshit, and going at him, everybody has different personalities. He gives a false confession. He thinks he can just go ahead and clear it up with his attorney, like, God, just get me out of here, get me my attorney, and we're going to clear all this up. Okay? Wouldn't that be no different than a victim saying that, okay, I'm just going to go ahead and do this, but then I'm going to go ahead and tell, once I get out of this situation, I'm going to go and tell somebody what truly has transpired here, okay, to get me out of this. But then, you know, I'm going to go then tell. So tell somebody what just happened here. And we're going to clear all this stuff up. Well, no, you had sex with them. You must have liked it. Why would you have sex with somebody if you didn't want to have sex with that 80-year-old that just raped you? I mean, what? Can you imagine saying that to somebody? That, well, you did it anyways. I mean, why'd you say yes if you really meant no? Dan Moore, in my opinion, was a victim to law enforcement's bullshit. Okay? But here the whole time, Jennifer Drake is perpetuating a false narrative and a false motive. Brian's just so good at his job. He's just, everybody wants to go see him. Just patience. Patience. Probably everybody's just so jealous of Brian. With defendant's motion for a preliminary injunction, he provided what appears to be anonymous letters to him calling him a killer and a murderer, but he does not offer any evidence which connects Jennifer Drake and the individuals who sent such letters. Well, you have to ask law enforcement why they would not take the DNA off of the licking of the envelopes, because I'm curious about that. All that the defendant offers are conclusory statements that he suffered harm and was subjected to unspecified public ridicule and disdain. Defendant cannot produce any evidence which shows that, but for statements made by Jennifer, he would not have received anonymous letters, he would not have experienced public ridicule and disdain, and he would not have closed his business. Defendant would have this court infer that a handful of Facebook posts to a group of approximately 800 people, what? That is not all she did, is the reason he has been the subject of disdain, and not the remarkable fact that he was charged with the murder of another chiropractor in this small community of Bonner's Ferry. Such an inference is unreasonable. It's funny that you say that, because I think that the whole damn investigation is unreasonable. But I believe that it all will change if the argument is that you must talk about what Jennifer Drake told dispatch, how Jennifer Drake attempted to conceal her whereabouts when making a 911 call, and all the media outlets that she spoke with when she knew Brian Drake was not the suspect of, the victim of that shot through the window. It's all hearsay, actually. And it should go against all eyewitness test timeline and actual surveillance cameras to prove, as well as phone records, as well as missing calls that should be there on Jennifer's cell phone, with the Kootenai County Dispatch, the CAD notes. I mean, this is absurd. But yeah, when you just put it that you think that that's all Like there's nothing there, like you're not proving any damages. In the event that the defendant claims that statements made by Jennifer in the course of these judicial proceedings are defamatory, such statements are obviously privileged and cannot form the basis of a defamation claim. There are 6 elements defendant must prove to prevail on his defamation claims. He cannot prove 4, according to her attorney. Because defendant cannot, the essential element of his defamation claims, they are subject to dismissal. 4, plaintiff's motion for summary judgment on defendant's defamation claims should be granted and the claim should be dismissed with prejudice. Defendant's other claims, this is B now, defendant's other claims are premised on his defamation claims. He cannot prove essential elements of the claims, and these claims should also be dismissed. Tortious interference with prospective economic advantage. Well, let me just tell you. Defendant claims plaintiff Jennifer Drake undertook to damage his practice further by publishing information about his reputation of practice and derogatory public commentary about defendant returning to work. And this was designed to undermine his practice and prevent patients from seeing him. I personally would go with the fact that y'all set my motherfucking ass up. And you took my fucking truck. But, you know, let's see what they say. Defendant also claims plaintiff Jennifer Drake reported him to the Idaho Chiropractic Board in an attempt to have his license as a chiropractor revoked and thereby removing his ability to practice. Is that true? Holy shit, you troll. Defendant summarily concludes that such conduct was wrongful and constitutes tortious interference with prospective economic advantages of defendant. She called the board. A cause of action for tortious interference arises from either the defendant's pursuit of an improper objective of harming the plaintiff or the use of wrongful means that in fact cause injury to plaintiff's contractual or business relationships. I would love to know what Emma Fields was spreading around about Dan Moore. Do you know that every person I tried to call and an interview and let them know that I was interviewing them, every single person, Dan Moore, that murderer. Have you talked to Jennifer Drake? Have you talked to Jennifer Drake, Dan Moore, that murderer? Oh, I can't talk to you until you talk to Jennifer Drake to say it's okay. Fuck, she your mom? What? Out of here. Yo, out of your mind. Please. For defendant to prevail on his claim, he must prove 1, the existence of a valid economic expectancy. I think Dr. Moore had an expectancy to be continuing his chiropractic work there all well through until he decided to not do it anymore. So the existence of a valid economic expectancy. Number 2, knowledge of the expectancy on the part of the interferer. So yeah, she knew, Jennifer Drake knew, you would have to think if you're going to make up this motive, okay, of chiropractic, blah, 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 as well as he had to be killed because he is such a good Christian. We had the best marriage. Nobody's cheating. Nobody's having affairs. He doesn't have a password on his phone. Like, oh my God. He is such a Christian man. Like, you'd have to think and know that by you creating this false narrative and illusion of your fucking lives, that Dan Moore would suffer. I mean, intentional interference inducing termination of the expectancy. 4, the interference was wrongful by some measure beyond the fact of the interference itself. Was fucking totally wrong. And 5, resulting damage to defendant whose expectancy has been disrupted. I mean, I personally think that that Jennifer Drake going out and claiming and making it seem like she's not a suspect. She's going out, working with law enforcement, being given all the criminal discovery, and going out in March and saying that, oh, we know who did this. We just need more evidence. We need more. We need more. We need more. Like, to satisfy the knowledge of the element, defendant is required to present evidence that Jennifer Drake had actual knowledge of the prospective economic advantage, or she had knowledge of facts which would lead a reasonable person to believe that such interest exists. She had knowledge of that because her husband, the only place that he made money was Bonner's Ferry. Okay. Also, if Brian's dead because you and your friends had something to do with it, okay, Brian or Jennifer would know that being a chiropractor in Bonner's Ferry was on the scale that even her husband did it part-time. That's what paid their bills. Without his presence in Bonner's Ferry, Brian makes pennies. To prove intent, defendant must demonstrate that Jennifer desired to bring about the interference or knew that the interference was certain or substantially certain to occur as a result of her conduct. If Jennifer Drake is intent, if Jennifer Drake's honest with the police in the first place, do they ever even interview Dan Moore? If the police do their job and first clear with alibis and do their due diligence and put together a timeline and truly look into what people say versus just saying, okay, that sounds great. Do we ever get to the point that Dan Moore is being hauled in? Me personally, absolutely fucking not. Remember back in the beginning when I said I would have just answered this, laid low, answered this, okay? Stayed it, and never had to fucking deal with this shit? I personally believe that Miss Bolton's filing was premature. She didn't have enough information because she didn't have a good team of investigators and researchers. Otherwise, I think that her countersuit would have been like fucking tits. Instead, it's probably shit. I don't even know. It's crazy. Again, so you have to prove that intent there. The interference must be wrongful by reason of established standards of trade or profession or conduct in the violation of a statute regulation. She also knew that because she also ran Brian's business according to her. Defendant must have admissible evidence that Jennifer either A, had an improper objective or purpose to harm defendant. Yeah, in order to save her fucking ass. She had an improper objective. B, Jennifer, quote unquote, used a wrongful means to cause injury to the prospective business relationship. Yeah, I mean, what the fuck do you think that was going to happen when she's going to go out and tell the world that we know who did it? We just need more. This means defendant must also prove that Jennifer had a duty of non-interference. And I believe that she did have a duty of non-interference because Jennifer knew that Dan Moore didn't fucking kill anybody. So she had a duty because of the knowledge that she possessed not to fucking perpetuate bullshit. Even if she, hey, like, I don't care what the police are saying to you. If you know something because you have personal knowledge, because you were directly involved, then yes, she has a duty. And then yes, she would obviously know that all of this shit is going to fucking affect him. But again, how do you prove that? Well, you prove it by showing the lies. You prove it by why is Jennifer Drake lying? Why can't she substantiate any of her claims immediately after her husband was allegedly shot? You got anybody that's a lawyer that's going to watch this, how would you go about the fact that a ISP detective lied in a probable cause affidavit? A probable cause affidavit which got search warrants. That if that shit would have never fucking happened, if the police don't lie in affidavits, probable cause affidavits, to get search warrants to be able to search, not even, it doesn't matter that anything came from it, because nothing did come from any of these search warrants. It's the mere fact that you're like, it's just very interesting how you would want to go about attacking this beast. Because I think you have no other choice but to have all these motherfuckers as co-defendants to prove your case. You'd have to have, when Jill Bolton went ahead and filed with a federal case against the county and the city and these officers, okay, then they countered this, okay? So she's got two cases going at the same time, but really, if she would have had a fucking good goddamn researcher and an investigator on her fucking team, okay, I promise you that the way that this would have been attacked would have been completely different. No doubt about it. Like 100% hands down, this would have been attacked differently. And I'm telling you, the number one thing would have been, you would have never countered this fucking bullshit. You would have answered it, stated, fucking through that shit, never even fucking worried about it, because the Buchanan said this isn't going anywhere until the criminal case is. And then you have Jill Bolton coming through saying, oh, we just want to, no objection to getting this fucking, let's do the civil case. Why? What are you doing? What are you talking about? Why would you do the civil case? You have a stay. I don't give a fuck what Jennifer Drake wants. Jennifer Drake's not going to get it. There's a criminal case that's saying it's without prejudice. So they can bring it back at any point in time. Why would you subject your client to ever undergoing depositions and fucking sitting through a goddamn civil case that it works differently? You would never fucking do that unless you were out for money, motherfucker. Unless it padded your bank accounts. Would you ever lift and be like, we're not going to object. Yeah, we're going to go ahead and do this. How dumb of a move is that? I think that's fucking stupid. Everybody knows that's stupid. And you only do it for one reason. And it's my opinion that I think Dr. Moore has a case against Jill Bolton. Because it's against, lawyers can't go around. Like, these are your duties. And your duty is to your client. Your finances do not come before your client. Hello. Fucking A. This is just wild to me. Fucking this poor family that they've been through. Could be worse. You could be Jennifer Drake and on your way to women's fucking correctional system here soon. Defendant cannot prove each essential element of his claim for interference with prospective economic advantage. On its face, defendant's claim is subject to dismissal since he fails to even allege the termination of an economic expectancy. Notwithstanding defendant's pleading failure, defendant cannot produce admissible evidence which establishes that Jennifer had actual knowledge or knowledge of facts which would lead a reasonable person to believe that a prospective economic advantage existed. And that is not true. She 100% possesses and has actual knowledge or knowledge of facts which would lead a reasonable person to believe that a prospective economic advantage existed. And that would be the knowledge that she possessed on who the killers were in her husband's case. And that Dan Moore, if even just for the mere fact of being accused and that ever getting out in a small town, is damaged. That Jennifer desired to bring about the interference, or that she knew that the interference was certain or substantially certain to occur as a result of her conduct. Fuck yeah, she did. Oh my God, I cannot believe you could fuck this up any worse than I feel like you've already done. I can't fucking believe what I'm reading right now. Or that Jennifer had an improper purpose to harm defendant or used wrongful means to cause injury to his business. Defendant also cannot provide admissible evidence that the claimed interference induced termination of the expectancy or resulting damages. All defendant can establish is his self-serving opinion that Jennifer making a single Facebook post that he returned to work was designed to undermine his practice and prevent patients from seeing him. That's exactly what it was to do. She got it out to the little Mennonite community. I cannot. Defendant neither alleges that this single Facebook post actually undermined his practice or actually prevented any patient from seeing him, nor does he have any admissible evidence to prove such claims. Well, I would hope that some people were deposed in this situation. Depose his patients and ask them if they didn't go back to see Dr. Moore because of the murder charge. And then ask them if based off of this Facebook group post or the march going out and 9B News, wherever the fuck it was, I don't know, whatever news channel picked that up. Did they see that and did they take issue and were like, I'm not going there, and we felt like other people shouldn't go there, and we know people like, yeah, people were blacklisted. We were blacklisting him in the community. I don't get it. I would have been deposing everybody. I would have been deposing I'm deposing every patient Dr. Moore ever had. Get your ass in here. Why haven't you been back to see him? Celinda, get in here. Clickbait channel by, I don't know how it says exactly what it is. Who really killed Brian Drake? You can't get these documents anywhere else. Fucking idiot. Jackie. God, I love unknown. I love when people come in though and do it. I love it. Jennifer's statement that defendant returned to work is truthful and does not contain any message directed to his patients to refrain from seeing him or communicate a desire that his patients stop seeing him. Likewise, nothing about the statement is wrongful, but a reasonable person is going to know that anybody that would be charged with murder, you are not, that's going to damage your everything. I mean, for fuck's sake. Jennifer's statement that the defendant returned to work is truthful and does not contain any message directed to his patients to refrain from seeing him or communicating a desire that his patients stop seeing him. Likewise, nothing about the statement is wrongful by reason of an established standard of trade or profession or because it violates a statute, regulation, or rule of common law. Defendant's other basis for his claim is that Jennifer reported him to the Idaho Chiropractic Board in an attempt to have his license as a chiropractor revoked and thereby remove his ability to practice. How is that not interference? Especially that bitch knew that he didn't fucking kill anybody. By defendant's own admissions, the claimed report was unsuccessful. It doesn't matter if it was unsuccessful. She attempted to do what? It's like saying, oh, they conspired, but guess what? They failed. It doesn't matter. It doesn't matter the outcome. She attempted to do something for what? For what purpose? She had intent. She did it. And for what? She didn't call up the board to say, oh my God, he's the best chiropractor ever. By defendant's own admission, the claimed report was unsuccessful, and he made the ultimate decision to close his practice because of public ridicule and disdain, and not because his license was revoked. How about this? Brian Drake was seeing patients in Montana, motherfuckers. Did Brian Drake have a license to see patients in Montana? How about that? Is that why Jennifer Drake lied to the police when asked, did your husband have an office in Montana? Did he see patients in Montana? And she's like, no. He fucking saw patients in Montana. He worked on the cartel. Fuck, Jennifer. They did interviews at this damn church of all the people that he saw. Do you want me to read off the Libby, Montana fucking client list? Shit. Damn lie. I don't think Brian had a license to perform any type of massaging in Montana. The claimed report to the Idaho Chiropractic Board thus did not result in termination of any prospective economic expectancy. Defendant cannot produce admissible evidence to prove all 5 elements of his claim. Likewise, his defamation claim. This claim is subject to dismissal because he cannot prove each essential element. Well, guess how the courts felt about that? They said, no, this is continuing on. Plaintiff motion for summary judgment on defendant's interference with prospective economic advantage claims should be granted, and the claim should be dismissed with prejudice. Well, I don't believe that was the outcome there. I believe that it continued on. And the last one here is intentional infliction of emotional duress. Defendant alleges that Jennifer published information designed to portray him as a murderer. She did. Published a false narrative about herself and her husband, Brian Drake. She did. Attempted to cause the revocation of his chiropractic license. She did. And published derogatory public commentary about his return to work, which was designed to interfere with his livelihood and his relationships with his patients. Exactly. Defendants claims such conduct was extreme and outrageous. Don't you think that that's extreme and outrageous? Can you believe somebody knowing that they didn't commit this murder and she's just this Christian woman just going to keep on plowing through knowing that this man did not do this? She says, in order to establish a claim of intentional infliction of emotional distress, defendant must prove that 1, Jennifer's conduct was intentional or reckless. Yeah, I think that we can prove that. 2, remember, Jennifer's conduct was intentional or reckless. Remember this whole claim about, oh, Jennifer didn't do anything until after, he was arrested. That's bullshit. Jennifer, from the moment that she's ever engaged with law enforcement on any capacity, okay, her conduct was reckless and intentional. Number 2, Jennifer's conduct was extreme and outrageous. I don't know what else it would be called. Number 3, there was a casual connection between Jennifer's wrongful conduct and defendant's emotional distress. And 4, the emotional distress was severe. Dr. Moore was violated, abused, and framed, period. 100%. And the question is who was involved? So how about this? They say that, the courts have required very extreme conduct before awarding damages for the intentional infliction of emotional distress. Summary judgment is properly granted when the alleged conduct could not be reasonably regarded as so extreme and outrageous as to permit recovery. Conduct cannot be unjustifiable without rising, quote unquote, to the level of atrocious and beyond all possible bounds of decency that would cause an average member of the community to believe it was outrageous. I believe that Jennifer Drake's actions are outrageous. Okay. Where the defendant has done no more than to insist upon his rights in a permissible way, even though he is well aware that such instances is certain to cause emotional distress, liability for international or intentional infliction of emotional distress does not lie. As set forth above, any statements Jennifer Drake made about defendant are entirely based on defendant's confession to law enforcement. Get the out of here. Get out of your mind. Again, as set forth above, any statements Jennifer made about the defendant are entirely based on defendant's confession to law enforcement on August 27, 2020. And what she learned from law enforcement and from court proceedings in the criminal case. And that would be absolutely not true. Despite defendant's contention that he made a false confession to law enforcement, it remains true that he told Assistant Chief Ryan that he shot and killed Brian Drake. It was not Jennifer Drake who portrayed defendant as a murderer. It was defendant's own words. His admissions, which implicated him, and the second-degree murder charge. None of Jennifer's communications amount to conduct which was extreme, outrageous, and wrongful. Lying to law enforcement is extreme, outrageous, and wrongful. In fact, it's a crime when you are obstructing justice. An average member of the community would not consider a crime victim's continued belief that the man who confessed to the murder of her husband and her communication of her opinions based on that belief was atrocious. Do you know what a false confession is? Number one. Number two, did you know he had an alibi witness in Mick Mallet? When did you know about that? When did Jennifer Drake know that Dan Moore had an alibi? It's going to be really interesting when that question comes up. I think it's already come up. None of Jennifer's communications amount to conduct which was extreme, outrageous, or wrongful. An average member of the community would not consider a crime victim's continued belief that the man who confessed to the murder of her husband and her communication of her opinions based on that belief was atrocious beyond all possible bounds of decency or outrageous. You're right. Until we talk about what Jennifer Drake knows. But how do you prove to the jury that Jennifer Drake knows that Dan Moore didn't do it? How do you prove to the jury that law enforcement knew that the timeline was fucked? How do you win this case? How do you win this case? And I'm saying it's my belief, this is how I would go about that, is when they say that it was not Jennifer Drake who portrayed defendant as a murderer, it was 100%. You have a murderer walking amongst you in Bonners Ferry. Those were her words. Anything that would have came from law enforcement, they never went out publicly and said that, okay? They never held a press conference. Law enforcement, in fact, didn't say shit about this. So when they say it was not Jennifer Drake who portrayed defendant as a murderer, it was defendant's own words, to a false narrative that Jennifer knew was false. Because Brian never told Jennifer that he was shot through the window, because Brian and Jennifer never fucking talked from 7/17 to 7/26, as she claimed. Jennifer's own narrative to the 911 law enforcement, that's her narrative. She's not repeating what law enforcement told her. She's repeating what she told law enforcement. And that was never properly vetted by law enforcement. But she knowingly, she knew it was false. She knew that his confession was false. They all probably were shitting their pants when they got this man fucking, I cannot believe he fucking just. None of Jennifer's communications amount to conduct which was, can't believe that. As for the other conduct which defendant claims harmed him, defendant readily admits that the claimed report to the Idaho Chiropractic Board was unsuccessful. And Jennifer merely communicated in her Facebook post that defendant returned to work, which was true. It's just no big deal that she tried to call. Defendant's motion for preliminary injunction. Such conduct was not extreme, outrageous, or wrongful. How could you say that it wasn't wrong to call his work? I guess you'd have to get a report of what she said, because we don't know what was said on that call. Such conduct was not extreme, outrageous, or wrong. Lastly, whatever narrative Jennifer shared about herself and Brian is of no consequence to defendant. Defendant is not entitled to a specific story about the victims, which makes him look less culpable. Jennifer has no legal obligation to say anything about her relationship with Brian or their marriage, hardships, or successes. Any outrage and public disdain defendant has experienced is a result of his actions and his confession. We'll see about that. Plaintiff did not engage in any extreme, outrageous, and wrongful conduct which was intentional or reckless and caused defendant severe emotional distress. Defendant cannot prove each essential element of his claim for intentional infliction of emotional distress, and the claims should be dismissed with prejudice. Well, what do we got here? Defendant's response to plaintiff's motion for summary judgment. So defendant responds to this shit show. Let's see. Preliminary, it should be noted that plaintiff's summary judgment motion relies on defendant's December 9, 2020 answer and counterclaims. That answer and counterclaims have been amended, and the newest answer and counterclaims were filed on June 30th, 2023. Oh, wow. So there was an amended complaint. This error is material as additional factual allegations and claims are set forth in the June 30th, 2023 amended answer and counterclaim. Oh! So out the gate, they're saying Jennifer Drake's team lied. This response relies on the defendant's amended answer and counterclaim. Well, it is undisputed. Great. That Brian Drake was shot in the back and died from a gunshot wound on March 12th, 2020. Who shot him and who may have been involved in this killing is very much in dispute. Boom, shake it. Well, it is undisputed that Brian Drake was shot in the back and died from a gunshot wound. Who shot him and who may have been involved in this killing is very much in dispute. Indeed, it will be the core issue of the wrongful death claim brought by the plaintiff. As will be shown at trial through numerous witness statements, at the time of his death, the person with the greatest motives to kill Brian Drake was Jennifer Drake. Oh my God! What? Okay! Oh shit! Oh fuck! Hell no! Let me say that sentence one more time. As it will be shown at trial through numerous witness statements, at the time of his death, the person with the greatest motives to kill Brian Drake was Jennifer Drake. Hot damn. Damn. Okay. Dan Moore coming out swinging. Is this the right piece of paper? Defendant's response to the plaintiff's, everything that we just read there. This is the response to that. Holy shit. Well, nonetheless, law enforcement failed to undertake any meaningful investigation of Jennifer Drake or members of her immediate family or associates as suspects. It is axiomatic that when a married man is killed, especially one with the troubled married life history that Brian and Jennifer Drake will be shown at the trial to have endured, the primary suspect in the investigation should be the spouse. Oh, shit. Instead, lead ISP Detective Van Leuven cleared Jennifer Drake to collect her $1 million life insurance policy on April 1st, 2020, less than 30 days after Brian Drake was shot. A $1 million life insurance check was issued to Jennifer Drake on April 6, 2020. Like hundreds, if not thousands before him, Dr. Daniel Moore was subjected to a custodial interrogation that resulted in a false confession. This confession was suppressed for violations of Miranda on February 12th, 2021. And the charges brought by law enforcement dismissed for lack of probable cause. Lack of probable cause, motherfucker, on April 14th, 2021. Lack of probable cause. Damn. The Idaho Supreme Court affirmed that the confession required suppression for law enforcement's violation of Miranda and confirmed that the state's charges required dismissal for their failure to meet the threshold burden of probable cause on August 31st, 2022. State versus Moore. It's in the books. Defendants' counterclaims filed on June 30th, 2023 involve 3 causes of action for defamation, 1 cause of action for tortious interference with prospective economic advantage, and 1 cause of action for intentional infliction of emotional distress. The defamation claims involve Jennifer Drake's public social media posts and statements to broadcast and print news media implicating defendant Dr. Daniel Moore in the murder of Brian Drake. The defendants will show that through these public statements, plaintiffs implicated Dr. Daniel Moore in the felonious crime of murder, made statements by implication in which they alleged they knew with certainty that Dan Moore was the killer and thereby defamed him, interfered with his ability to continue his chiropractic business in Bonners Ferry, and intentionally inflicted emotional distress upon both he and Jane Doe. undisputed facts substantiating these claims and demonstrating material facts in dispute that prevent summary judgment are incorporated herein and filed herein. Oh God, let's see what's up. Woohoo! Factual and procedural history. Let's see what the facts over here say. Plaintiffs, through Jennifer Drake, filed their original complaint on November 20th, 2020. So I think there's a dispute already. I think November 6th is what they claimed over there. November 2020. Well before the criminal charges against Daniel Moore were dismissed. Despite Judge Buchanan's finding that Dr. Moore's so-called confession could not be used against him in any subsequent criminal proceeding, not only because of their egregious violations of Miranda, but because of the unlawful tactics employed by law enforcement in extracting the false confession, she not only proceeded with her civil complaint, she doubled down on her public campaign to convince the community that Dr. Moore killed her husband. The greed. She knew from the time of the ruling, or reasonably should have known, that though Dr. Moore made statements implicating himself in the murder, it was far from certain that what he told police was true, but rather the product of a psychological coercion. Further, after all this time and all the investigative work focusing on Dr. Moore as the perpetrator, including her own billboard reward campaign to get information to confirm what we already know, no criminal charges have been brought against Dr. Moore. At the time of its confirmation of Judge Buchanan's ruling on the inadmissibility of Dr. Moore's statements due to law enforcement's repeated Miranda violations, the Idaho Supreme Court made it clear for Jennifer Drake that the state had not met even the minimal probable cause standard, that the charges against him required dismissal. What is she reading? This is Moore's rebuttal. Woohoo! Oh, for fuck's sake. At trial, the jury will hear about the numerous motives Jennifer Drake had to kill her husband or conspire with others to do so. Oh, fucking hell! Ah! Oh. Lana, can you say, wait, what? At trial, the jury will hear about the numerous motives Jennifer Drake had to kill her husband or conspire with others to do so. Boom. They will also hear about the complete lack of evidence of any motive for Dr. Moore to kill Brian Drake. The jury will hear testimony from Dr. Moore's alibi witness, Boundary County Coroner Mick Millett, confirming Dr. Moore was with him at the time of the murder, a fact of which he had a clear memory when he spoke to police on May 19th, 2020. I think he took a polygraph and passed it too. The jury is expected to find it far more likely that Jennifer Drake was involved directly in her husband's death and knew for certain that Dr. Moore was not her husband's killer. Fucking A. Say it, baby. Woo-hoo-hoo. The jury will also learn about the number of obvious false and contradictory statements Jennifer gave to police versus her deposition testimony. Jennifer Drake was deposed. Holy shitballs. Oh, exercise the demons. Wake your asses up over there. It's like only 8:58 p.m. in Idaho. Okay. Holy shit. The jury will also learn about the number of obviously false and contradictory statements Jennifer Drake gave to police versus her deposition testimony versus her verified answer to her interrogatories, and inevitably for forthcoming trial testimony that Jennifer Drake struggles with telling the truth when confronted with questions material to her husband's death. Oh my God. Holy shit. Oh yeah. Oh my God. You guys, I told you this shit's gonna be wild. It's gonna be lit at trial. Lit. The factual dispute set forth herein and contemporaneously filings establish that the jury must hear and decide the factual issues surrounding whether the plaintiffs, through Jennifer Drake's actions, defamed Dr. Moore, tortiously interfered with his prospective economic advantage, and intentionally inflicted emotional distress on him, as set out in detail in the amended answer and counterclaim, and is set forth herein. As such, plaintiff's motion for summary judgment must be denied. Summary judgment standard. To prevail on a motion for summary judgment, the movement must demonstrate that there is no genuine dispute as to any material fact. All disputed facts must be liberally. Construed in favor of the non-moving party, and all reasonable inferences from the record must be drawn in favor of the non-moving party. So basically, like, let's let the jury decide what the heck's going on here, okay? Boom. Shh. I know you know, but TNT members want to make sure Dr. Moore isn't trying to take our... Wait, what? Oh, shit. Argument. It is notable that the plaintiff's motion relies almost exclusively on the transcript of Daniel Moore's statement to law enforcement on August 27, 2020, and the probable cause affidavit of ISP Detective Michael Van Leuven. Hoo-wee. You guys know that? So basically, it gets this PCA that you have, and then the statements made by Dr. Moore on the 27th of August. The Idaho Supreme Court has found that without the so-called confession of Dr. Moore, the state had failed to establish even the minimal probable cause standard to permit their pursuit of the murder charges they brought against Dr. Moore. They didn't even meet the threshold for probable cause. Thus, their reliance on Van Leuven's affidavit is misplaced. The strength of that shit. Thus, the reliance on Van Leuven's affidavit is misplaced as the Idaho Supreme Court agreed with Judge Buchanan had not met the reasonable and probable cause standard necessary to hold Dr. Moore to answer for the second-degree murder charges. So all you guys talking about, like, Brian Kober, why isn't this shit getting dismissed, blah, blah, blah. Well, here's a case where not only was it dismissed without prejudice, but the Supreme Court affirmed the dismissal because it lacked the probable cause threshold. That means what they brought to the table at the preliminary hearing, minus the confession, the false confession, they didn't meet the standard. So what the fuck are y'all going to court with in this civil case? What are you going to court with? Because the civil cases, threshold is just not, is like the burden's just not, it just has to be just a tinsy over. Just a tense. Okay. So, further, though the charges could not be refiled with any available proof they have obtained from their investigation of Dr. Moore today, the state has not done so in the nearly 3 years since the charges were first dismissed by Judge Buchanan on May 12, 2021. This provides the compelling inference that the reason no new charges have been filed is because the state still does not possess the reasonable or probable cause standard to refile the charges against Dr. Moore. To the extent that the plaintiff's motion relies on the declaration of Jennifer Drake, this response will address her defamatory statements implicating Dr. Moore in the murder of her husband explicitly, which constitutes defamation per se. Fuck. Shit. Oh my God. Hold on. This is getting me hard over here. Hold on. Woo! Love a good doc. Damn. I have to get a ice water for this one. This is giving people in Idaho blue balls. Put some ice in your balls. Woo! Yeah. Should start drinking the Twisted Teas. It's 9 o'clock in Idaho. 9 o'clock. Cheers. I'm pouring some out for my homies. Have all the fun you want in chat. You guys, this is crazy. Maybe it's just me, but I love a good doc. Knock, knock. Who's there? Duck, duck. Where was I in this amazing read so far? All right, so here we go. Oh, to the extent that the plaintiff's motion relies on the declaration of Jennifer Drake, this response will address her defamatory statements implicating Dr. Moore in the murder of her husband explicitly, which constitutes defamation per se. Awesomeness. Additionally, the jury will hear about her defamation by implication. Damn, Idaho. Defamation by implication arises not from what is stated, but from what is implied when a defendant, You get one or two. So a series of facts so as to imply a defamatory connection between them, or two, creates a defamatory implication by omitting facts such that he may be held responsible for the defamation implication unless it qualifies as an opinion. Additionally, as will be discussed further below, this court in reviewing this matter should decide that Jennifer Drake's defamatory statements do not qualify as opinion, as they are statements implicating Dr. Moore in the murder of her husband, which involves an objective fact that is capable of being proven as true or false. A statement which is provable as true or false, such as a claim of perjury or other objectively provable crimes, removes the statement from any so-called opinion exemption. Unlike a subjective opinion, the averred defamation language is an articulation of an objectively verifiable event. With regard to the puzzling insertion of the ruling from Judge Windmill in the collateral federal claims which Dr. Moore and his wife pursued against the ISP detectives Van Leuven and Tolson, the Bonners Ferry Chief of Police Zimmerman, Assistant Chief of Police Ryan, and the City of Bonners Ferry has no bearing on the issues in this case. The memorandum decision in order of the United States District Judge Windmill relates to the impact of Vega on Dr. Moore's Fifth Amendment based on Section 1983 claim against the law enforcement and city defendants. Constrained by that Supreme Court decision, a ruling that Judge Windmill notably described in an earlier ruling as judicial activism, the Moore's Fifth Amendment-based Section 1983 claims failed. The Moores were also constrained in the pursuit of their due process-based Section 1983 claim by the Idaho Supreme Court's ruling that Dr. Moore's confession was not coerced under Idaho law. Regardless, that Judge Windmill employed the res judicata principle in the federal case and thereby was unable to permit the Moore's case to proceed on due process coercion grounds, does not constitute an independent finding by Judge Windmill that the confession was not coerced under federal law. Regardless the outcome of the federal case, but now all the information that I've uncovered, that federal case that was dismissed without prejudice could be fucking sought back after. Because I think that I've uncovered so much more information that that would change that case. Just saying. Regardless of the outcome of the federal case, that occurred long after Jennifer Drake engaged in the conduct set forth in defendants' counterclaims has absolutely no bearing or relevance in the legal issues before the court in this case. Further, the Idaho Supreme Court's finding in his criminal appeal that Dr. Moore's August 27, 2020 statements to law enforcement did not constitute coercion under Idaho law does not prevent the jury from hearing scientifically based expert testimony establishing that Dr. Moore's statement was the product of psychological coercion. Oh my God, here we hear it for the first time. Are you serious? Does Dr. Moore have a false confession expert that we will be seeing at trial? Just as Dr. Moore would be entitled to introduce expert testimony that people confessed to crimes they didn't commit and that his confession was false and the product of psychological coercion, so too will he have the opportunity to explain it in this case. Expert testimony is admissible if it will help the trier of fact to understand the evidence or to determine a fact in issue. Whee! That's the Federal Evidence Rule 702A. Our case law recognizes the importance of expert testimony when an issue appears to be within the parameters of a layperson's common sense, but in actuality is beyond their knowledge. Thus, Tico held that a jury could benefit from Dr. Blanton Gillen's expert knowledge about the science of coerce and interrogation tactics, which law enforcement employ, and how psychologically coercion tactics could elicit false confessions. Oh my God, I think we're going to see a false confession expert. Because false confessions are beyond the common knowledge of the average lay person, jurors would have been better equipped to evaluate the confession itself had they known the identified traits of stress-compliant confessions. Holy shit, they're doing it. We're going to be seeing a false confession expert. Holy shit. A, plaintiffs through Jennifer Drake committed defamation per se of Dr. Moore. To the Spokesman Review and other print and broadcast news media, Jennifer Drake made several attempts, including but not limited to the following. I think, oh, hell no. On March 8th, 2023, the Spokesman Review published statements Drake made in which she referenced her wrongful death action against Dr. Daniel Moore. The billboard she put up in Bonner County and its associated reward, by 10 grand? They're talking about my 10 grand, guys. I'm like, it's not been claimed yet. Okay. That's my 10 G's. All right. So she put up this big billboard. She put up in Bonner County and its associated reward for information in her case and said she was 100% certain that Moore killed her husband. On March 29, 2023, Jennifer Drake appeared on a KHQ broadcast regarding her billboard campaign, portraying her husband as essentially the perfect father and husband, and describing at 3 minutes and 40 seconds into the broadcast that the billboard campaign was to get information to confirm what we already know, in quotes. In the Brian Jennifer Drake Facebook page, which she controlled, she posted many statements about Dr. Moore, including but not limited to the following written statements. On August 31st, 2020, before the preliminary hearing. Holy shit. Jennifer Drake commented that there are two sides to every story except the story that Moore killed her husband, implying that since Moore confessed, there is no question but that he murdered her husband. November 12th, 2020, Jennifer Drake posted an affidavit filed in Dr. Moore's criminal case and pronounced that Dr. Moore had returned to work at his chiropractic office in Bonners Ferry. In that same post, Drake said that Dr. Moore killed her husband because of greed. He's a greedy fuck. Oh, shit. Oh, my God. Greed. In the Justice for Brian Drake and the Bonners Ferry community Facebook page, which she controlled, Jennifer Drake posted written statements that included, but were not limited to, February 12, 2021, Jennifer Drake posted that Judge Buchanan had suppressed Dr. Moore's confession. He confessed with details only he could know. None of those details are right. That's what's great about it. False confession, you guys, is when whatever you're confessing to does not match the evidence. Okay? He confessed with detail only he could know. That is all that should matter, in my opinion. In my opinion, the judge's article does not represent what occurred that day at all. How the fuck would she know what occurred that day? I bet you do know, girl. This broad, man. November 12th, 2020. Attaching an affidavit of probable cause for search warrant from the State versus Moore case. She was just attaching search warrant. How did you have the affidavit of probable cause for the search warrant from the State versus Moore case on November 12th, 2020? How the fuck did you have that, Jennifer? As Dan Moore is back to work, the galvanized spirit of law enforcement is working hard for this trial set for April 12th. Because she felt, no, you don't, just because you file a civil case, you don't get the criminal discovery. That's crazy. You don't, that's absurd. No. Wait, what? Wait. November 12th. Wait, when was it? November 12th. Permitting responsive posts and her own statement from her Brian Drake Facebook page account, clearly designed to spark outrage that Moore was working among her followers on this public site, including but not limited to the following comments. Oh, the comment section. Oh. Karen Shively commented, I can't believe Moore is working, unquote. Catherine, in quotes, I would think his license to practice would be suspended if he was under investigation for murder. Oh, shit, Catherine. I would expect that that's probably what gave Jennifer Drake the idea to call the board. Addie said, in quotes, I read the entire affidavit. How'd you get that? And I'm just baffled how this man is back to work. Oh, I'm just baffled at your fucking stupidity, Addie. How about that? Because that affidavit is fucking shit. Dee Dee commented, cowardly, cold-blooded killer. Moore deserves life in a psychiatric prison. The fuck, Dee Dee? Lily says, I'm baffled that Moore is still practicing. Have you reported him to the chiropractic board? Ah, see right there. Brian, Jennifer Drake says, yes, I have. They told me they will look into it. God, what a psycho. My opinion. Brian Jennifer Drake says, attaching search warrant affidavit in State versus Moore. Brian's murderer chose to act as God and take the life of another human being. You are sick, woman. You are one sick, sadistic fuck. Dan Moore tried to act like God. Well, what do you consider you acting like right here in this little picture when you're trying to get into his phone? Get out of your mind. Jesus. I kid you. We've tried to keep the devil from coming out of the floorboards. Glitch says, I'm leaving. Why? She was banging Van Leuven. That's Ew. Well, let's take a look. Ready? In quotes. Brian's murderer chose to act as God and take the life of another human being. Wow, girl. Monica says, in quotes, I still don't get it. What was the reason? Jennifer comments back. Greed! No, Jay, that's all you, baby, now. That's all you. It's a double dip fest in here. November 13th, 2020, post from Amanda in response to the 11/12 post above stating, quote unquote, word is showing up on the internet and review systems. Justice for Brian. Attaching Care Dash reviews showing poor reviews for Dr. Moore's chiropractic services. Then they go over and they start both giving his online review. Oh, what a bunch of pigs. Then it goes silent on the front until May 12th, 2021. Post announcing Judge Buchanan's dismissal of charges, describing the dismissal as corruption and stating that Moore was getting away with murder. Can you believe Jennifer Drake's talking about corruption? I'm fucking dead. Girl, you wild as fuck. May 22nd, 2021, post announcing Judge Buchanan's decision will be appealed to the Idaho Supreme Court. She said, this is not a cold case. Give me that cold cut. January 15, 2022, post to Justice for Brian Drake Facebook page. She announcing the date of the Supreme Court appeal hearing would be in March and stating that Brian's murderer, in quotes, has chosen to take us through a nightmare for the last 2 years. Oh, fuck! Are you being serious right now? She said Brian's murderer has chosen to take us through a nightmare for the last 2 years, but I'm confident the truth will prevail. You're goddamn right it's about to prevail. You were confident about that. Obviously implicating Moore in the context of the appeal hearing being set in State versus Moore. Orlando Oriani would come along and just... March 12, 2020, she says, this is not a cold case. We know who murdered Brian. I bet you do, baby girl. I bet you do. We're not disputing that. Nobody is disputing that you know, Jennifer, who killed your husband. You guys, this is fucking crazy. At the time she made each of these statements, Jennifer Drake has testified that she did not know that Dr. Moore murdered her husband, that she did not witness him killing her husband, and could not, as she told the Spokesman Review, be 100% certain that Dr. Moore killed her husband. She also confirmed her knowledge that false confessions occur. Further, as is made clear throughout her numerous posts, she was being supplied with search warrant affidavits in the criminal case and updated on decisions rendered by Judge Buchanan that she contemporaneously posted about. She had access to and was aware that Judge Buchanan's memorandum decision and order entered on February 12, 2021 found that Dr. Moore's confession would be suppressed and not usable against him at trial because of law enforcement's violation of law, including his Miranda rights, and of the judge's opined that Moore's confession was the product of the police being a byproduct of police coercion in violation of due process. So too was she aware that Judge Buchanan denied the state's motion to reconsider her suppression of Dr. Moore's statements on April 14th. She was also aware that Judge Buchanan dismissed the charges against Dr. Moore on May 12, 2022, because the state had failed to establish to the magistrate at the preliminary hearing the requisite for quote-unquote reasonable or probable cause to believe that the defendant has committed the crime for which he was held to answer. As for what she knew at the time of her defamatory posts or statements to the press, she had no objective information that Dr. Moore killed her husband because of greed. She knew or should have known that Dr. Moore had posted a $500,000 bond to secure his release from custody prior to the dismissal of the state's charges pending against him, thus did not appear to be motivated to kill her husband for financial reasons, you fucking bitch! Isn't that the biggest oxymoron out there? Do you think that Brian Drake and the family over there could afford, if roles were reversed and Brian Drake was picked up for murder, would they be able to post $500,000 bond? She was aware, or should have been, that Dr. Moore had an alibi witness, Boundary County Coroner McMillette. An alibi witness who knew because he had an emergency pager which broadcast information about the shooting of Brian Drake, that Dr. Moore was with him from entire time that included the time prior to Brian Drake's shooting until after the notice came on his pager of the shooting. The essential elements of defamation are set forth in IDJI 4.82 and include each of the following elements. Number 1, the defendant communicated information concerning the plaintiff to others. Number 2, the information impugned the honesty, integrity, virtue, or reputation of the plaintiff or exposed the plaintiff to public hatred, contempt, or ridicule. 3 is the information was false. And 4, the defendant knew it was false or reasonably should have known that it was false. And 5, the plaintiff suffered actual injury because of the defamation. And finally, 6, the amount of damages suffered by the plaintiff. Further, where the defamatory statements are shown to implicate the person in a crime chargeable by indictment or information and subject that person to imprisonment or death, the statement is defamatory per se without the need for the damages to be proven by the plaintiff. You fucking morons! What do you think would happen to somebody? They can't fucking work when they're in prison. Of course they're going to be damaged. We don't have any money. Indeed, where the alleged defamatory language is plain and unambiguous. God, I can never say that sometimes. I'm moving on. It is a question of law for the court to determine whether it is defamatory per se. Otherwise, it is a question of law for the jury. Ladies and gentlemen of the jury, upon this court's finding that the defamation was plain and unambiguous, there you go, regarding Jennifer Drake's many public and published statements implicating Dr. Moore as her husband's murderer, this court should instruct the jury according to Idaho's slander libel per se jury instructions, which provides for presumed damages as follows. Where's my 10K? Where's Jennifer Drake's alibi witness? I want Jennifer Drake to take a polygraph on a live feed. How about this? If I can talk Dan Moore into taking a live feed polygraph, Jennifer Drake, would you take a live feed polygraph? I have 2 channels. I'll run them simultaneously and we'll live feed 2 polygraphs. What do you think? Again, they want them to read these rules, which is the plaintiff is deemed to have been injured by the defamation in this case, and the plaintiff need not prove actual injury in order to recover damages. And that's a rule. The Idaho Supreme Court recently engaged in an in-depth discussion about how defamation jury trials should proceed and the important factors in defamation claims. On the merits to succeed in a defamation claim, a plaintiff is required to prove that the defendant, A, or 1, communicated information concerning the plaintiff to others, 2, that the information was defamatory, 3, that the plaintiff was damaged because of the communications. A defamatory statement is one that tends to harm a person's reputation. usually by subjecting the person to public contempt, ridicule, or by adversely affecting the person's business. With regard to proving damages, the court also made clear that statements that rise to the level of defamatory per se do not require proving special damages. A statement is defamatory per se when it imputes conduct constituting a criminal offense chargeable by indictment or by information, either at common law or by statute. And as of such any kind, it is what it is. The fuck do you think is going to happen when somebody get out of here? Thus, there will be no question but the statements of Jennifer Drake made, which implicated Dr. Moore in the murder of her husband, constitutes defamation per se under Idaho law. This is true regardless of whether the jury finds Dr. Moore liable for Brian Drake's death. Ooh, that's an interesting twist. So think about that. So basically, what Dr. Moore's attorney here at the time, Joe Bolton, said is that thus there will be no question but that the statements Jennifer Drake made, which implicate Dr. Moore in the murder of her husband, constitute defamation per se under Idaho law. That this is going to be true regardless of whether the jury finds Dr. Moore liable for Brian Drake's death. B. Jennifer Drake's statements do not qualify as opinion. They are defamatory per se. Oh, shit. Jennifer Drake asserts that she must not be subjected to a defamation claim because her numerous public comments implicating Dr. Moore in her husband's murder were merely expressions of her opinions and involve facts that she submits must be true. First, the jury will need to decide if her statements were true. Jennifer Drake doesn't get to decide this. Jennifer Drake, you do not get to decide if your statements are true or not, okay? Okay? You are not the fact finder here. The jury is. So, again, first, the jury will need to decide if her statements were true. Jennifer Drake doesn't get to decide this. Further, unless she changes her previous testimony in which she admitted that she did not witness Dr. Moore shoot her husband on March 12, 2020, that she cannot know that her statements were true. Indeed, she can only know if they are false. She also was aware that false confessions happen. Her statements that implicate Dr. Moore in the murder of her husband are objectively verifiable facts, not subject to an opinion defense. Dr. Moore will provide evidence that his confession was a false confession. Defendants have disclosed the opinion of one of the nation's prominent experts in the field of false confessions. Shut the fuck up. Holy shit. They went and got themselves a damn good false confession expert. Defendants have disclosed the opinion of one of the nation's prominent experts in the field of false confessions, Dr. Leo, PhD, JD, which finds that Dr. Moore's confession is properly classified as a coerced complaint false confession. Holy shit balls! His review of the interrogation of Dr. Moore came to the following conclusions. One, Daniel Moore's interrogation induced confession statement is almost certainly, if not certainly, false. It bears numerous indicia and hallmarks of unreliability and no indicia or hallmarks of reliability or trustworthiness. If false, Dr. Moore's confession statement is properly classified as a coarse complaint false confession. Number 2, Bonner's Ferry Assistant Chief Ryan and Idaho State Police Detectives Van Leuven and Tolson's interrogation of Daniel Moore on August 27, 2020 that led to his confession statements is consistent with the empirical social science research on the types of interrogation techniques, methods, and practices that explain how and why innocent individuals are often moved to make and or agree to false, unreliable confessions. Holy shit, there's 9. Holy shit. Assistant Chief Ryan and Detectives Van Leuven and Tolson's interrogation of Daniel Moore on August 27, 2020 was psychologically coercive. It involved the use of psychologically coercive interrogation techniques, methods, and strategies that have been shown to cause suspects to perceive that they have no meaningful choice but to comply with the demands and requests of their interrogators, and thus led to involuntary confessions. Oh my fucking God. Assistant Chief Ryan's and Detective Van Leuven and Tolson's interrogation of Daniel Moore on August 27, 2020 was guilt, presumptive, confirmatory, and confession-driven. The interrogation was structured to break down Dr. Moore's denials of guilt and to incriminate him by pressuring and persuading him to agree with and admit to the investigators' pre-existing and non-evidence-based speculation that he killed Brian Drake. The investigators' guilt presumptive interrogation was not structured to assess the reliability of any information the investigators learned from Dr. Moore, but to confirm their pre-existing theories. Fuck yes. Holy fucking shit. Oh, woo! Hallelujah. This guy had to cost some cheddar. Fucking A. Dr. Leo Callie. Dr. Richard Leo, right? Leo is internationally recognized for his pioneering empirical research on police interrogation practices, the impact of Miranda. Whole fucking curtains. Holy fucking shit. Oh my God. Oh, his CV. Damn. Woo! Damn. Coming with the 1-2. Number 5. Assistant Chief Ryan and Detective Van Leuven and Tolson's interrogation of Daniel Moore on August 27, 2020 involved the use of psychological interrogation techniques, methods, and strategies that have been shown by social science research to increase the risk of eliciting false and unreliable statements, admissions, and or confessions, which are known as situational risk factors, when misapplied to the innocent. This included a premature presumption of guilt based on a reckless disregard for the fucking truth. False evidence ploys, minimization, and maximization, threats, and fucking promises. If you say that you just meant to, shoot him, but you didn't, you just meant to shoot through the window to scare him, it's totally different than what your motive. Like if you were really trying to kill, then it's just like, 7 years, and or otherwise it's the death penalty. Number 6, Assistant Chief Ryans and Detective Van Leuven and Tolson interrogation of Daniel Moore on August 27th, 2020 involve multiple instances of police interrogation, contamination, leaking, and disclosing non-public case facts. Holy fucking shit, let me be an expert. I've been saying this all goddamn day. Dr. Leo, thank you so much. Boom. Oh. Leaking and disclosing non-public case facts and police interrogation scripting, pressuring and persuading the suspect to accept the police narrative of how and why the alleged crime occurred. Which increased the risk that Mr. Moore's confession statement would misleadingly appear to be accurate and self-corroborating. In their interrogation of Daniel Moore on August 27, 2020, Assistant Chief Ryan and Detectives Van Leuven and Tolson violated numerous police investigative and interrogation national training standards, protocols, and commonly accepted best practices that existed in 2020. God, yes, I knew they did. Detectives Van Leuven's and Tolson's questioning of, oh my God, the coroner, Mickey Millett, on August 27, 2020, was an interrogation, not an interview, and involved the use of improperly suggestive, deceptive, and manipulative pressure and persuasion techniques designed for the interrogation of criminal suspects, not for the interview of fact witnesses. These techniques included accusations of lying, attacks on denials, false evidence ploys, minimization, and implicit threats. In their interrogation of Mickey Millett on August 27, 2020, Detectives Van Leuven and Tolson used psychologically coercive interrogation techniques for the purposes of eliciting third-party testimony, evidence to incriminate and fabricate a case against Daniel Lee Moore to get the alibi witness to flip that fit their factually unsupported, preconceived assumptions about the murder of Brian Drake. I fucking love this shit. Holy God. The investigators' interrogation of Mickey Millett was an attempt to pressure and persuade Mickey Millett to regurgitate the investigators' pre-existing theory of the crime rather than attempt to find the truth. Fuck yeah. That's exactly what it was, you sick fucks. Further, Dr. Moore's alibi witness, former Boundary County Coroner Mick Millett, will testify that Dr. Moore was with him at the time of Brian Drake's murder. Jennifer Drake failed to post any reference to Dr. Moore's alibi, let alone the decisions by Judge Buchanan finding that the law enforcement agencies had violated Dr. Moore's rights, engaged in coercive tactics to extract a confession, and failed to establish the probable cause necessary to proceed with their criminal charges against him. She knew these things at various stages of her published defamatory remarks, but intentionally omitted them in order to support her persistent narrative that Dr. Moore killed her husband. These two facts alone, combined with the admissible evidence of Jennifer Drake's numerous false statements and motives to commit the murder herself, will raise questions that a jury must decide in finding for or against the plaintiff's claims and in finding for or against the defendant's claims. Let's go to the jury. Plaintiffs also misunderstand the law relating to their claimed defense that Jennifer Drake's statements were merely opinion and protected by the First Amendment. As the U.S. Supreme Court has made clear, there exists no additional constitutional privileges for opinion. In a defamation action, nor is one required to ensure the freedom of expression guaranteed by the First Amendment. This is Milkovich versus Lorraine Journal. The Milkovich case established that the quote-unquote the dispositive question in a defamation claim is whether the published statement implied perjury by Milkovich implies an assertion that the petitioner committed the crime. So the Supreme Court found that Lorraine Journal Company's published article, which stated that Milkovich, quote-unquote, lied at the hearing after having given his psalms, so and was not sort of a loose figurative speech. Let's see. Nor does the general tenor of the statement negate the impression. Also, a statement which is provable as true or false, such as a claim of perjury or other objectively provable crimes, removes the statement from any so-called opinion exemption. Unlike a subjective opinion, the averred defamatory language is an articulation of an objectively verifiable event. Thus, the numerous statements to the media and on her Facebook pages by Jennifer Drake that Dr. Moore killed her husband include that, quote-unquote, greed was the reason. Dr. Moore was getting away with murder, and the dismissal was the result of corruption of the legal system when the charges against Dr. Moore were dismissed by Judge Buchanan on May 12, 2021. Rather than the truth of Judge Buchanan's ruling that law enforcement did not establish reasonable or probable cause to permit the case to proceed. That this is not a cold case when Moore's case was being appealed to the Idaho Supreme Court. And to print and broadcast media that we are looking to confirm what we already know. Who's the motherfucking we? And that she was 100% certain that Dr. Moore killed her husband, as well as all the other defamatory statements implicating Dr. Moore in the murder of her husband as set forth herein, were defamatory per se. Plaintiffs, through Jennifer Drake, tortuously interfered with Dr. Moore's economic expectancy of a continued and lucrative chiropractic business when she explicitly made public comments explicitly and implicitly implicating Dr. Moore as a murderer. You guys, I think this jury is going to be like, holy shit. What is Jennifer Drake thinking? What do you guys think so far? You guys think, holy shit. He is like one of the best false confession experts in the country. Oh, holy shit. Wow. Oh, wow. After Jennifer did her summary judgment and they answered that, then Dan Moore's team fucking slapped Jennifer Drake with a fucking summary judgment of their own. Holy fucking shit. Like 300 pages. 300 fucking pages. Oh, second amended complaint and jury demand. Oh, fucking A. That's what I want to see. This is like Delphi. This is like a Frank's. Holy shit. Oh my god. She filed the declaration. These posts were not only letting individuals know that Dr. Moore was back to work, but directing her followers to believe that Dr. Moore murdered her husband. Drake ensured her followers on her public Facebook page knew full well that she was referring to Dr. Moore had implicated repeatedly in the murder of her husband. Indeed, she specifically attached to this post ISP Detective Van Leeuwen's probable cause for the search warrant of Dr. Moore's properties and businesses. Drake also confirmed for a follower that she had contacted the Idaho Board of Chiropractic to report charges. You guys want me to stop? Oh my god. I want to hear I want to see this amended fucking shit, because I'm telling you, some dirty ass shit. Drake was not only interfering with Dr. Moore's constitutional right to the presumption of innocence, she was set out to fully destroy his reputation and ability to work in the community. Exactly. Because at the time that she did all that, ultimately, the disdain Drake promoted to destroy him and his business resulted in threats of violence against him. Sent to his business on Main Street in Bonners Ferry, making the decision to leave the community and abandon his practice necessary. Dude, Satan is coming through the floorboards right now. To prove an economic expectancy, an enforceable contract need not be shown to exist. Dr. Moore had a valid economic expectancy to remain in Bonners Ferry, Idaho, and to return to his professional reputation in the community, both when charges were pending and he was presumed innocent, and after the charges were dismissed. Respondent claims that Dr. Moore's claim is subject to dismissal as, quote unquote, he fails to even allege the termination of an economic expectancy. It is undisputed that Dr. Moore was a chiropractor in Bonners Ferry for over 20 fucking years. Despite his best efforts to try and maintain his business, Dr. Moore was forced to shut his doors in 2022 due to Drake's persistent defamatory statements that Dr. Moore was Brian Drake's murderer. Dr. Moore was unable to maintain the flow of patients that he once had and was forced to leave town to ensure his safety due to the multiple death threats he received. When Dr. Moore was released and the criminal charges were dropped, Drake took it upon herself to ensure her biased concept of justice was executed by persisting with her false claims. Respondent further claims that defendant cannot prove each essential element of his claim for interference with prospective economic advantage. Dr. Moore owned and operated his successful chiropractic practice, Moore Chiropractic, from 1997 through 2020, prior to Drake's interference by publishing defamatory statements relating to the Dr. Moore's return to practice. Dr. Moore was a pillar in the community, and between the years of 2015 to 2019, Dr. Moore's practice generated a net revenue ranging from this to this and cash profit ranging from this to this. It was expected that Dr. Moore would continue practicing until retirement age. Therefore, Dr. Moore's claim to a valid economic expectancy has not only risen above the level of speculation, but this evidence to be provided through Dr. Moore's expert witness. Oh my God, he's got an expert motherfucking witness. She's providing a question of material fact only appropriate for a jury to determine. It's a fucking forensic auditor. They did it for, he had his fucking finances forensically audited. And these motherfuckers are not paying taxes. Running a cash business with little pens and pencil markings. Knowledge is satisfied by actual knowledge of the prospective economic advantage or by knowledge of facts, which would lead a reasonable person to believe that such interest exists. Yeah. Drake not only had actual knowledge of the prospective economic advantage, she had knowledge of facts, which would lead a reasonable person to believe that such interest exists. Dr. Moore successfully ran his practice in the town for over 2 decades. Jennifer Drake claimed that when her and Brian Drake left Texas in 2012 and sold Drake Chiropractic of Austin, they sold a very successful practice. Jennifer Drake was not only aware that Dr. Moore owned and operated a chiropractic clinic, as she clearly posted her disdain on Facebook for his return to work, but she intentionally perpetuated a narrative that Dr. Moore was guilty of a crime of which he was never convicted. This was not just any crime. It was the crime of murder. Based upon the fact that Dr. Moore's operation of Moore Chiropractic in Bonners Ferry for over 20 years would lead a reasonable person to believe that the interest of economic advantage existed. Dr. Moore was a pillar in the community, and despite his arrest and prosecution, but for Jennifer Drake's campaign against him, if it wasn't for her exerting all of her energy, he would have had the opportunity to return to practice. An inference can be deemed to be intentional if the actor desires to bring it out or if he knows that the interference is certain or substantially certain to occur as a result of his actions. Drake desired to continue her mission towards ensuring that Dr. Moore was held responsible for the murder of Brian Drake without certainty that Dr. Moore was the killer, and further without confirmation of a criminal murder conviction. It was clear by her Facebook post on May 12, 2021, that her intention was to hold Dr. Moore accountable civilly and financially because the state's criminal case had fallen apart by then and the charges were dismissed. Further, Drake reported Dr. Moore to the Idaho Chiropractic Board to have his license as a chiropractor revoked, and thereby demonstrating her active pursuit of destroying Moore's ability to practice. To prove intentional interference with the other's prospective contractual relationship is intentional if the actor desires to bring it about or if he knows that the interference is certain or substantially certain to occur as a result of his actions. She's such a fucking pig. God, what a hoe. When is the civil trial? It's in January. It's going to be nothing but Moore and Drake and Karen Reed over here. I mean, this is wild. Ooh, it's noteworthy to say that the negative business reviews on Dr. Moore's chiropractic Facebook were not made immediately after his arrest in August 2020, but much later in November 2020, after Drake's Justice for Brian page was started. Talk about timelines. Drake's defamatory statements were made with the intent to defame and put an end to Dr. Moore's return to work. Drake's actions were kindred to painting murderer in red across his business door, and the necessary consequences of her action was damaging Dr. Moore's ability to continue his... Wait, what? Oh, it was basically like doing that. Comparatively, the appellants in Highland may not have specifically intended to harm Highland Enterprises, but a reasonable person would deduce that delaying the construction of a road would cause economic damage to someone, as any reasonable person would deduce that claiming somebody is a murderer would have negative effects on one's reputation. I mean, come on. Both personal and professional in a field where reputation is everything. Even if Drake intended to inform, as she claimed, by directing individuals to her new Justice for Brian Drake page, a reasonable person can infer that her defamatory publications directly pinpointing Dr. Moore as a murderer would damage Moore Chiropractic. Drake was very aware of the ethics of a practicing chiropractor, as her husband practiced in both the state of Texas and the state of Idaho. Drake took it upon herself to contact the Idaho Board of Chiropractors to report Dr. Moore, as she stated in response to the plethora of Facebook comments. What a psycho. Oh, wow. Idaho Administrative Code Division of Occupational Professional Licenses, Board of Chiropractic Physicians Appendix A. Chiropractic Physicians Code of Ethics requires a report to the board within 30 days following the conviction of a felony or a crime of dishonesty, theft, violence, habitual use of drugs or alcohol, or sexual misconduct. Dr. Moore was not convicted of a felony nor any other crime, and Drake falsely reported him to the Idaho Board of Chiropractic Physicians, evidencing her clear intent to cause injury to Dr. Moore's prospective business relationship as a chiropractor in the state of Idaho. Holy shit, she knew it was unethical what she did. By her being the business manager of Drake's chiropractic business, as she claims, if she would have went and read the Appendix A, it says there's a code of ethics. In order to report, it has to be within 30 days following the conviction of a felony or a crime of dishonesty, theft, violence, habitual use of drugs or alcohol, or sexual conduct. I mean, this is crazy. Dr. Moore lost his practice, his home, and the prospect of his retirement in beautiful North Idaho, where he raised his children and had lived and practiced chiropractic medicine for decades. He lost this opportunity because of Drake's intentional publication of defamatory statements. A person asserting a claim of damages has the burden of proving not only a right to damages, but also the amount of damages with reasonable certainty. Reasonable certainty does not require mathematical exactitude, but only that the amount of damages be taken out of the realm of speculation. Whether Jennifer Drake's intentional behavior that caused severe emotional distress to the defendants was extreme and outrageous is a question of fact and should be left for a jury to decide. A reasonable jury can and should determine whether Drake intentionally inflicted emotional distress on Dr. Moore. Notwithstanding the presumption of innocence and the right to a trial by a jury of peers afforded to every individual in the United States, Drake has pursued an relentless campaign to establish Dr. Moore's guilt in the eyes of the public. These intentional acts have caused great emotional harm to Dr. Moore and his family. Sick fuck. Whether the conduct is extreme and outrageous depends on the facts of each case. Drake has made allegations of criminal behavior. A reasonable jury in this case could find that making numerous and unsubstantiated allegations of criminal wrongdoing could qualify as extreme and outrageous conduct. Drake's actions, if not intentional, were absolutely reckless. Any reasonable jury could find that the actions demonstrate a callous disregard for the profound emotional distress inflicted by her false accusations of murder. How about when you are the fucking one that did it? What does it make it then? Defamatory. When you know something to not be true and you say it, knowing that you know it's not true, that's defamation. She knows that fucking Dan Moore did not kill her husband. By explicitly naming Dr. Moore in her inflammatory social media post and announcing his return to work, she incited a wave of community hostility and condemnation toward him. She simultaneously published a false narrative about herself and her family to garner support and sympathy, not only on her social media platforms, but to some of the largest local news media stations in the area. She continued making implications that Dr. Moore was a murderer despite there being no conviction and despite the lack of filed charges for 4 fucking years. Moreover, Drake shamelessly proclaimed her unwavering certainty of Dr. Moore's guilt in the murder of Brian Drake, as evidenced by her statements in the spokesman review as being 100% certain that Dr. Moore murdered Brian Drake. Drake claims that Dr. Moore's intentional infliction of emotional distress is completely tied to his defamation claims. However, this is untrue. While many of her defamatory statements have led to the emotional distress of Dr. Moore, she also made other public statements that, even if not considered to be defamatory, can only be interpreted as intending to cause Dr. Moore distress and implicate him in a crime. For example, Drake implies that her social media post about Dr. Moore returning to work was not defamatory because it was true and therefore not intended to inflict emotional distress. However, this post is a perfect example as to why the emotional distress Drake caused is not completely tied. She did not merely communicate that Dr. Moore had returned to work. Rather, she included the probable cause affidavit from the criminal case and responded to various comments with her narrative of events. Fuck yes! Her narrative of events. Not what the fucking police told her. Her narrative. I would say that this inference was adopted by not only the community, but also the fucking popo. These actions were not only outrageous, but extreme in their blatant disregard of the fundamental rights afforded to every citizen in our country. Despite overwhelming evidence exonerating Dr. Moore, including a fucking alibi, Drake continues to cling and clench her pearls to Dr. Moore's false confession in August of 2020. She actively ignores the mountain of real evidence that Dr. Moore was not involved in the murder of Brian Drake. She also actively ignores the uncontroverted science around false confessions and that the Idaho State Police's investigation was lackluster at best. That's being so kind. Her relentless campaign to validate her preconceived biases has not only been damaging, but also dangerous. Jennifer Drake. The repercussions of Drake's she's just diabolical. They've been severe and irreparable. Dr. Moore's business suffered a barrage of derogatory reviews from individuals influenced by the Drake's Justice for Brian Facebook page. Moreover, Dr. Moore and his wife were subjected to horrifying anonymous letters from the Watchers, quote unquote, the Watchers. These letters did not begin until after Drake's cruel social media campaign against Dr. Moore and eventually led to Dr. Moore and his wife having to abandon the community they had raised their children in and wholeheartedly embraced and supported for over 2 decades. That's fucking so sick. And meanwhile, Jennifer Drake's out there saying that Bonner's Ferry to her is disgusting and she would never raise her kids there, that she thinks that she's too good, that she's too good for Bonner's Ferry. Let me give you a fucking wake-up call, Jennifer. Your ass is going to be in a fucking padded room cell, okay? Like prison. Dr. Moore's severe emotional distress was exacerbated by Drake's relentless defamation and public animosity has necessitated trauma-based counseling. Jesus Christ. Jennifer, you are just sick. Now, let me see some dirt here. Oh my God. Shut the fuck up. Give it on up for expert witness number 2. Holy shitballs. Financial forensics. They have a forensic fucking... Shut up. Holy shit. Well, they have somebody to prove their damages. Holy shit. Oh, bye-bye. Oh my God. This sounds more and more like the Amber Heard versus Johnny Depp trial. Total defamation of character. Yeah, that's exactly what it is. I mean, wow. This report contains my opinions related to the economic losses suffered by Daniel Moore in compliance with the Idaho Rules of Evidence. My opinions were formed based upon my research and documents and information reviewed as of this date. All opinions expressed herein are done so to a reasonable degree of economic certainty. I reserve the right to supplement the opinions and conclusions expressed in this report should additional information be provided to me in this manner. Whoo! Dude, Jennifer, holy shit! Dr. Moore went out and got himself a fucking false confession expert, one of the best in the country, and got himself a fucking financial forensics company. Shit. Holy shit. Financial forensics, yeah. Holy shit. My opinions assume that counter defendants are found to have liability for the actions alleged in this counterclaim using Dr. Moore's federal income tax reporting for his business, Moore Chiropractic Center, the clinic for the years 2015 to 2022, and other information referenced in this report. Dr. Moore's economic damages were computed as follows. You're so fucking fucked. Holy shit. General information. According to the counterclaim to Jennifer Drake's complaint, Miss Drake defamed Dr. Daniel Moore through her repeated false claims in various media outlets, including social, print, and broadcast media, that Dr. Moore murdered Brian Drake. Dr. Moore was wrongfully arrested, charged, and incarcerated for the crime of second-degree murder that he did not commit. He was arrested on August 27, 2020, released from jail on October 13, 2020, when he posted bond and security dismissal of the charges against him on May 12, 2021. It is alleged, and I have assumed, that Jennifer Drake's actions caused economic damage to Dr. Moore and his chiropractic practice, from which Dr. Moore's earnings are derived. Oh my God. Holy shit. Dr. Moore is a self-employed chiropractor physician. He owned and operated a chiropractic clinic, Moore Chiropractic Center, in Bonners Ferry since 1997. The clinic was located at 6812 Main Street. Upon his arrest, Dr. Moore's provider agreement with health insurer Blue Cross Blue Shield was terminated by the insurer. Thus, his services were no longer covered by insurance for his patients. Bonners Ferry, while being the largest city in Boundary County, Idaho, is a small community in a rural county. The city of Bonners Ferry is located 27 miles south of the Canadian border on the Kootenai River. The city is the county seat of Boundary County, Idaho. The following demographic information was obtained from the Hometown Locator website and the United States Census Bureau website. The city of Bonners Ferry has a population of 2,672 people. This was back in July of 2022. And it's the largest city in Boundary County. Wow. The next largest is the county Moye Springs, which has a population of 874 people. Boundary County has a population in totality of 12,418 people. By comparison, Kootenai County has a population of 181,000. Why the fuck was Brian Drake live in Kootenai County, where 181,000 people reside, and travel 2 days a week, stay the night in a little town that has 2,600 people? Boundary County population per square mile is approximately 9.5. By comparison, Kootenai County's population per square mile is 138.4. I was asked to evaluate the past and future economic losses suffered by Dr. Moore resulting from Ms. Drake's actions, and assuming counter defendants are found to be liable for the actions alleged in this dispute. In my analysis, I utilized documents and information which are listed in Appendix 2. Oh, wow. He has his QuickBooks report. Wow, he documented his cash, unlike Brian. IRS forms. Oh my God. Oh my God. My calculations assume that the actions of the counter defendants caused economic damage to Dr. Moore's earnings in his business from August 2020 to at least the end of Dr. Moore's status, his work life expectancy, and resulted in the destruction of Dr. Moore's business as a going concern and total loss of business value. Oh my God, these numbers. Oh my God. This is horrible. This is absolutely fucking horrible. I'm so sick. Please, Lord. Unfucking believable. This is so disgusting. Wrong. Ooh. This is just the Supreme Court ruling. It's on the website. It's like one of the Idaho, like, I don't know. It's like the highlighted case. Financial forensics is interesting. Yeah, this is unreal, man. Nobody should have to pay for a defense like this, though. You know what I'm saying? Like, oh, amended. Number one, plaintiff Dr. Dan Moore has since August 27, 2020, lived the unimaginable nightmare of having been wrongfully arrested and charged with second-degree murder and suffering the disgrace of having provided a false confession to a crime he did not commit. The false confession was extracted by law enforcement in violation of clearly established laws that require that police cease all questioning of a suspect in custody when the suspect requests counsel. The false confession was extracted by the overreaching and abusive tactics employed by the law enforcement that coerced the false statements in violation of Dr. Moore's due process rights. After extracting the false confession, law enforcement broadcast their apprehension of a confessed killer and charged Dr. Moore with second-degree murder. Consequently, plaintiffs Dr. Moore and his wife have lost their ability to continue to live and work in what was their home and in their community in which they had raised their children and prospered. They have been shunned, badgered, and banished, and their lives have been threatened. The Moores' strong and close marriage of over 40 years was severely negatively impacted by the incarceration of Dr. Moore, the very serious criminal charges lodged against him, and the emotional distress created by such charges. Karen Moore lost her husband's companionship, love, and affection during his incarceration and the period thereafter in which the impact of the defendant's wrongful conduct towards Dr. Moore caused emotional distress to them both. This emotional distress and loss of consortium continues. The officers deliberately denied Dr. Moore his constitutional secured rights by ignoring his multiple requests for assistance of counsel threatening first-degree murder charges if he didn't confess, and using other abusive, overreaching, and coercive techniques to extract a false confession. The false confession followed a lengthy custodial interrogation in which Dr. Moore requested counsel no less than 4 separate times, but counsel or an opportunity to contact counsel was not supplied. While Dr. Moore attempted resumption of his chiropractic business and his life in the community of Bonners Ferry after he was released from detention and after his charges were dismissed, doing so what was not effectively possible because of defendants' action and inactions. Defendants Chief of Police Zimmerman, Assistant Chief Ryan, ISP Detectives Van Leuven and Tolson have failed to undertake reasonable efforts to locate the actual perpetrator of Drake's murder, thereby failing to fully exonerate Dr. Moore. Instead, ISP Detectives Van Leuven and Tolson and Boundary Ferry Police Department, Zimmerman and Ryan have stood by their position that Dr. Moore is the perpetrator. Fucking idiots. After Dr. Moore's release from jail, and after his criminal charges were dismissed for a period spanning approximately 1 year, officers of BFPD, at the direction and under the supervision of defendants Zimmerman and Ryan, persistently stalked Dr. Moore's business, driving their marked patrol vehicles up and down the alleyway next to his business, and parked their vehicles in public view of the location of Dr. Moore's business in Bonners Ferry. Further, even today, long since Dr. Moore's criminal charges were finally dismissed by the district court, the city of Bonners Ferry and ISP have maintained custody over personal property secured during the execution of warrants to search Dr. Moore's personal residence, business, and real properties, refusing multiple requests at the Moore's personal property, including personal computer, be returned. Jesus, what a bunch of fucking idiots. Dr. Moore and Miss Moore bringing this lawsuit. This is the lawsuit that they found to hold those accountable who illegally caused the unlawful extraction of a false confession, the filing of a criminal charges based on the false confession, and the resulting incarceration for a crime Dr. Moore did not commit. Damn. This is when they just sued the world. Oh, God. Holy shit, listen to this. During the period that included the early months of 2020, Dr. Drake would spend approximately 2 nights per week in Bonners Ferry, where he would see patients and spend the night away from his family in Hayden, about 71 miles away. During one such trip to Bonners Ferry on March 12, 2020, not long after seeing his last patients of the evening, Dr. Drake was shot through the window of his office and struck with a bullet in his back, causing his death. This is what they're alleging, you know. Dr. Drake's office was situated approximately 16 feet from a building to the southwest known as the Far North Coffee Lodge. The space between Drake's office and the Far North Coffee Lodge was utilized as a drive-through window for the coffee shop. The Far North Coffee Lodge was owned and operated by defendant Ryan's brother-in-law, and Ryan's wife worked at the coffee shop's drive-through window, where Brian Drake just fantasized about that blonde. Well, Well, Ryan's brother-in-law and his wife would naturally have some information about Dr. Drake and his business and patients coming and going from his office. No investigative interviews of these witnesses were supplied to Dr. Moore's defense team. Dr. Drake saw his last patient on March 12, 2020, Eldora Gatchell and her brother Caleb Pico Nazara around 7:17 p.m. that night. The timestamps from Dr. Drake and his wife's telephone conversation made by Drake after his patients left established that Drake was shot at approximately 7:26. This is what they're saying. Okay. Eldora Gatchell and Caleb Pico Nazara would report seeing a two-toned white and tan Ford style pickup truck near Drake's office building when they were leaving. You know what's funny about that two-toned? They said it was white. Okay. That two-toned Ford is a dark green / bluish, that two-tone with a tan, bottom round. That's a Ford Explorer. Anyways, Dr. Moore's vehicle at the time of Dr. Drake's shooting death was an all-white four-door 2019 Toyota Tundra. In his sworn affidavit for the probable cause to search Dr. Moore's residence, storage unit, business, and vehicles, and also to establish probable cause to charge him with second-degree murder, Van Leuven would not accurately describe the patient's description of the pickup truck as a two-tone white and tan Ford-style pickup truck. God, there were so many other things to say because I'm just totally baffled. Eyewitnesses describe Running Man and do not identify Moore in lineup. Funderburg's fiance, Aaliyah Sandelin, also heard the shots and observed the figure running away to the northeast. Funderburg and Sandelin were later each shown a photograph lineup that contained Dr. Moore's photograph. Neither identified Dr. Moore as the person they saw running from the scene of the shooting of Drake. Indeed, their description of the Running Man was of a person with different skin and hair color, an entirely different statute. Van Leuven just fucking doesn't. I mean, what a lying fat fuck. Oh my God. After charging Dr. Moore with second-degree murder, Marty Ryan confronted Mick Millett in a hostile way about having provided an alibi for Dr. Moore's whereabouts on the evening of Dr. Drake's murder. Ryan suggested that Mallett's alibi was causing people in law enforcement community to not want to work with him in his professional capacity as the county coroner. This conduct was egregiously designed to harass and dissuade Mr. Mallett from providing an alibi for Dr. Moore and violated the law of the state of Idaho, which prohibits efforts to intimidate witnesses to prevent their testifying in criminal proceedings. The Drake family and Jennifer Drake. At the time of Drake's death, his family was suffering financial hardship resulting from Dr. Drake's inability to meet the family's expenses with his business income. At or near the time of Drake's tragic death, the Drake family had resorted to seeking financial assistance from their church. At the time of Drake's death, Dr. Drake had developed an alcohol dependency, which greatly distressed his wife, Jennifer. Oh my God. The Drake marriage had also suffered some setbacks relating to inappropriate conduct by Drake. The Drake family had moved to Idaho from Austin, Texas, after Dr. Drake had inappropriate contact with a female patient in Austin. This female patient, through her legal counsel, had made a demand for payment for the injuries Dr. Drake had caused her and threatened legal action. Dr. Drake attempted to resolve this dispute on his own and offered money to the female patient to resolve this dispute. Jennifer Drake had also discovered other conduct by her husband that involved a serious violation of her trust. Yeah, I guess you could say that. God, if only I was around back then. Jennifer Drake had secured a $1 million life insurance policy covering the life of her husband, Brian Drake, prior to Drake's death, and said policy was in effect when Drake was shot. Prior to starting his own business, Dr. Drake had previously practiced with other chiropractors in the Hayden and Coeur d'Alene area. And upon information and belief, left those practices after inappropriate physical contact with a female staff member at one of the offices and pursuant to a dispute he had with one of the managing chiropractors in the other office. This is when he was slapping the ass of that fucking Savage woman. She was interviewed. God, I love that interview. He's saying he'd want to use my pigtails for handlebars and shit. What? Oh, sorry, I slapped your ass. You look like Jennifer. What? Jennifer Drake reported to law enforcement that she believed one local chiropractor with whom Dr. Drake had worked previously was the likely shooter because her husband had taken several of the chiropractor's patients when Dr. Drake left the practice to open his own practice. The fuck? This was a theme ISP and Bonners Ferry Police Department would pursue at Jennifer Drake's insistence, rather than pursuing Jennifer Drake as a suspect. Yeah, let's just follow what she says down the brick road. Notwithstanding the potential for Jennifer Drake's involvement in the death of her husband, law enforcement failed to completely investigate her as a suspect. Rather than competently investigate Jennifer Drake as a potential suspect in her husband's death, defendants provided her details of the investigation, including engaging in regular text messaging with her and following the leads she proposed they follow, including the lead that the person who killed her husband was likely another chiropractor who lost patients in business to her husband. Here's a fun fact for you guys. Ready? Dr. Moore was actually interviewed on March 24th, 2020. Just like how other people were being interviewed from like March 12th, 13th. Everybody was being interviewed with a recording device present. Multiple interviews were on March 24th, 2020, where Rich Alderson and Leslie Lehman showed up with their recording device and recorded their interaction. Except for one interview. Can you imagine what interview that would be on March 24th, 2020? Whose first interview was supposedly not recorded, even though every interview on that day with those two motherfuckers was recorded? Yeah, Dr. Moore's. Dr. Moore offered his full cooperation and denied any involvement with Dr. Drake or the crime they were investigating relating to his death. On March 25th, they just miraculously they went and saw, and there's a reason for it. Okay, there's a reason. Then on May 6th, Detective Alderson and Van Leuven met with Dr. Moore at Moore's office again to ask him questions. At this interview, like the one before, Dr. Moore denied having ever met Dr. Drake and denied having anything to do with his murder. This second visit by law enforcement focused on a gas leak that had occurred at Dr. Moore's office on Sunday, March 15th, that had rendered him unconscious. After Dr. Moore truthfully described the gas leak, Van Leuven and other law enforcement officers developed the unfounded theory that Dr. Moore had attempted suicide. I mean, this case needs to be the poster case for just the world's dumbest cops. They said that he tried to commit suicide from his overwhelming sense of moral distress over having killed fellow chiropractor Drake. Officers would later learn that members of Dr. Moore's staff had suffered headaches and complained of gas smell near the time of the gas leak that Dr. Moore had described, consistent with Dr. Moore's description of the event. Officers also learned during their May 6, 2020 questioning of Dr. Moore that he had suffered a leg injury that had rendered him incapable of running long before the murder of Drake. All you Idaho 4 listeners out there, during law enforcement's investigation into Dr. Drake's death, they compiled what they purported to be surveillance footage showing the whereabouts of Dr. Moore's white Tundra on the evening of Dr. Drake's murder. Van Leuven swore in an affidavit that the footage showed Dr. Moore driving his Toyota Tundra near the area of Dr. Drake's shooting on the night of the shooting and in the same time frame as the shooting. However, none of this footage is accurately time-stamped. None of this footage shows Dr. Moore driving the white truck depicted in the footage. None of the surveillance footage depicts a license plate of the vehicle which belonged to Dr. Moore. Desperate to name a suspect in their long-running investigation into Dr. Drake's death, law enforcement lured Dr. Moore to the Boundary County Sheriff's Annex for a custodial interrogation on August 27th. Law enforcement then frisked Dr. Moore and explained that they were taking him to a secure area, requiring them to check for weapons. Law enforcement secured the keys to the car Dr. Moore had driven to get there. Dr. Moore's cell phone was left inside his car. Apart from 2 subsequent bathroom breaks, law enforcement recorded the entirety of their interrogation of Dr. Moore on videos, except for these bathroom breaks. Less than 5 minutes into the interrogation of Dr. Moore, Van Leuven informs Dr. Moore that he is suspected of killing Dr. Drake and attempting suicide via gas poisoning due to a sense of guilt. Dr. Moore is quick to deny his involvement in Dr. Drake's death and naturally any consequential feelings of guilt or desires to self-harm. Following this accusation, Van Leuven and Tolson asked Dr. Moore a series of questions, establishing his ownership of a white Toyota Tundra pickup. Roughly 8 minutes into the interrogation, Van Leuven belatedly informs Dr. Moore of his Miranda rights. After being read his rights, Dr. Moore reaffirms his non-involvement in Dr. Drake's death and his total lack of relationship with the man. I've never met him. I don't even know him. I never met him. I don't know him. I'm sorry. Dr. Moore readmits that he drove to McMillet's house on the evening of March 12, 2020 in his white truck. Following Dr. Moore's repeated assertions of innocence, the detectives present him with an exaggerated accounting of the state's evidence they claim implicated him in Drake's homicide. After Dr. Moore continues to deny any involvement in Dr. Drake's death, Van Leuven suggests that the shooting was a mistake and that Dr. Moore simply wanted to scare the other chiropractor out of town due to some variety of professional disagreement. Over Dr. Moore's denials, Van Leuven falsely asserts that they had sufficient evidence to convict him of first-degree murder at a jury trial, pointing to surveillance video footage just like this. Like, I got all these things. He's like moving his papers. Fucking idiot. I got all these things against you. They claimed he put him in around the scene of the crime at the time the shot was fired through Drake's window. However, Van Leuven assured Dr. Moore that he would be facing a lesser homicide charge if he would simply admit that he had only intended to scare Dr. Drake when he shot into his window and did not mean to kill him. What's up, Heather? Van Leuven then informs Dr. Moore that law enforcement was, at that moment, serving warrants at his residence and business, and that his truck was also towed down to Coeur d'Alene pursuant to a warrant. Following several minutes in which the detectives apply pressure by telling Dr. Moore that they have proof of first-degree murder, and if he doesn't explain himself, they will bring those charges against him. Dr. Moore says, well, I didn't shoot him, and I'm sorry, but that's what it is. Dr. Moore then raises both of his palms facing the detectives in a stop gesture. Like, so I guess if you're going to do that, then I need to get an attorney. The clarity and lack of ambiguity in the assertion of his right to counsel is well understood by Van Leuven and Tolson that they fucking pick up their shit and leave. The detectives sigh in obvious displeasure at the required termination of their interrogation, gathering their things, standing up, and leaving the room. While leaving the interrogation room, Van Leuven asks Dr. Moore if he has a cell phone on his person. Dr. Moore responds in the negative and states that it's in his vehicle. Before exiting the room, Van Leuven instructs Dr. Moore to sit tight and indicated they would be right back. Law enforcement did not come right back. Dr. Moore sat in that room for approximately 45 minutes with no contact from anyone. While Dr. Moore sat in the interrogation room, Van Leuven and Tolson met with Ryan, who had been monitoring the interrogation of Dr. Moore. During this period of Dr. Moore's isolation, Van Leuven, Tolson, and Ryan decided that what Dr. Moore said was somehow unclear and that the interrogation would continue. But neither Van Leuven nor Tolson re-entered the interrogation room to seek clarification from Dr. Moore about his request for counsel. Instead, the collective decision was made to just send Ryan in there. He isn't even part of the goddamn investigation. ISP is in charge of this. You're going to send in a fucking assistant police chief? Can you imagine Fry saying, okay, let me just go in there? This is so funny. Instead, the collective decision was made to send Ryan in to resume the interrogation and leverage his pre-existing relationship with Dr. Moore, as they had known each other for many years and their children were involved in common activities in the community. When Ryan resumed the interrogation, he did not seek clarification of Dr. Moore's request for counsel, nor provide him with any opportunity to call counsel, but instead simply re-engaged the interrogation from a new angle, employing coercive tactics and suggests that, or techniques including moral appeals for an admission of guilt. Dr. Moore maintains his innocence throughout and provides explanations for accusations made by Ryan. Ryan demonstrates frustration and disdain for Dr. Moore's assertions of innocence and continues to press Dr. Moore for an admission of guilt. After a prolonged exchange, repeated accusations, discussions about how Ryan believed Dr. Moore had committed the crime and that it must have been an accident, combined with frequent moral, God even knows, prompting Moore responsive, I need to talk to an attorney then. I think I need to talk to an attorney. I want the truth, Ryan then instructs Dr. Moore that I want you to admit the truth. You're killing me, man. Okay, buddy? Dr. Moore responds by asking Ryan if he wants him to speak without an attorney. In turn, Ryan says he doesn't want Dr. Moore to do anything he doesn't want to do, but that he wants to be able to tell the community the truth. Expanding on his comment, Ryan admits that he is still attempting to interrogate Dr. Moore despite his request for counsel. I'm not trying to pull anything from you but the truth, thereby indicating his intent to keep the Dr. Moore talking so that the truth can be pulled out from him. At one point, Ryan comments that when I walk out this door, you are going to jail. Ryan then claims that Dr. Moore's only chance of avoiding jail time is to waive his right to counsel and continue to speak with him, stating that you are going to jail without a whole lot more explanation. This is sick. Then Ryan promises Dr. Moore that he won't be charged with first-degree murder if only he makes a statement. But I promise you this, if you do, I promise you, I'll go talk to him about what booking we're looking at. I promise you that, and it won't be first-degree murder. I can guarantee it. Whew. At this point, unknown law enforcement officer knocks on the door, prompting Ryan to exit the interrogation room. Dr. Moore requests to use the restroom, which was granted roughly 2 minutes later. Following this brief bathroom break, I can't wait to hear what happened in there. And despite his prior assertions that he would leave, Ryan returns to the room and continues his interrogation of Dr. Moore. Returning to the topic of Dr. Moore's request for counsel, Ryan mischaracterizes his 3 prior clear and unequivocal requests for counsel as somehow ambiguous. After Ryan asserts his supposed respect for constitutional rights several more times, he instructs Dr. Moore to tell me what you want to do. Dr. Moore states that he wants to speak with Ryan as he trusts him, but reaffirms his desire to have a lawyer present. Again, and notwithstanding Dr. Moore's clear request for counsel, yet again, Ryan asks him to explain his request. Dr. Moore states that he'd like to speak with Ryan, but inquires if, given the circumstances, it would be prudent to consult with an attorney about his options. Ryan once again affirms his intent to leave, but asks for additional clarification as if Dr. Moore's now numerous requests for counsel were somehow insufficient. In doing so, Ryan belittles Dr. Moore's attempts to exercise his fundamental constitutional right to counsel, saying he's done playing games. Finally, after dozens of past statements about his intent to leave and his desire to not infringe upon anything, Ryan finally leaves the interrogation room. Dr. Moore is left alone in the room for roughly a half a minute before ISP detective enters the room to give him some water and a blanket. Concerned about his property and pets, Dr. Moore asks the detective what is happening to his car and how the officers are searching his properties. The detective explains that his automobile is being towed and that his homes were being searched. After being told that his property was being seized and expressing concern about the safety of his pets, Dr. Moore requests to speak with Ryan one more time. Upon Ryan's return, Dr. Moore, befuddled and stuttering his will overborne, asks Ryan what he should do if he doesn't have an attorney, which he at this point has asked for repeatedly, but he's been repeatedly ignored. At this point, Ryan urges Dr. Moore onwards, not answering his questions about his right to counsel, but instead re-engaging this interrogation, discuss about the crime, mentioning the killing's impact on Bonner's Ferry, and ultimately back to asking questions about Dr. Drake's shooting himself. Dr. Drake's shooting itself, sorry. Whew. Ryan continues berating Dr. Moore for requesting his right to counsel, referring it to as a guilt trip. After referencing the need to heal the community, nobody was in need of healing. Ryan once again accuses Dr. Moore of laying a guilt trip on him when inquiring about legal counsel. After only 4 more minutes of badgering by Ryan, Dr. Moore attempts to ask a question stating, I just don't understand why, but is interrupted by perturbed grunting from Ryan. Fuck. Unable to finish, Dr. Moore falls silent, prompting Ryan to continue onward with another torrent of badgering. Fucking A. Eventually, after refusing to confess, Ryan accuses Dr. Moore of calling him back into the room for nothing. In response, Dr. Moore once again brings up the topic of legal counsel, which provokes Ryan to fawn in disgust and stand up. Dr. Moore explains that he wants an attorney so that he can be aware of his rights and expresses confusion as to why Ryan is not providing him with one. Ryan deflects by implying that a lawyer would not help Dr. Moore, as his only viable option is to confess. A lawyer ain't gonna help you, boy. Following this exchange, Ryan attempts to incentivize further communication with him by suggesting a confession would allow Dr. Moore to be booked for a lesser offense than murder in the first degree, a crime which carries a death penalty in Idaho. Having been badgered repeatedly about his request for counsel, law enforcement repeatedly failing to honor this, and repeatedly being told that he would be charged with first-degree murder absent an explanation of a lesser charge, Dr. Moore's will is ultimately overborne by Ryan. Dr. Moore then gradually adopts the elements of Van Leuven, Tolson, and Ryan's narrative, which law enforcement fed to him over the course of the motherfucking interrogation, y'all, which the best part about it is that it doesn't even match the fucking evidence because they didn't even investigate. So that's what's great about it, is that the false confession doesn't even match the goddamn evidence. So fucking great. So he implicates himself in Dr. Drake's death. Following Dr. Moore's false confession, law enforcement booked him. Dr. Moore's arrest and subsequent imprisonment were the direct result of unlawful extraction of a false confession by defendant Ryan Van Leuven and Tolson. There's text messages between Jennifer Drake and Detective Van Leuven, and Van Leuven inferring well before Dan Moore was ever arrested that there is this person of interest, and 100% I personally believe that the phone calls that they had, Van Leuven 100% to the name Dan Moore and was just giving her information just like he was the whole time with everything. That's how they were able to get in front of things, because then Jennifer Drake would make phone calls to people and then they would re-interview somebody, and then all of a sudden something would, oh yeah, Brian had a problem with this girl named Willa. Literally the day that Willa tells law enforcement that Brian's a pig. Just stupid. It's unbelievable stuff. Unbelievable. These people are just sick. God damn. What's this? You guys, I have some huge ass bombs. Like, the shit I found over the past 2 weeks is absolutely mind fucking blowing. But I can't. Jennifer watches all of this shit. I gotta leave some pows, you know? But all I have to say is, holy fucking shit. There's one person right now, two people I probably wouldn't want to be. And that would be like the district attorney of Norfolk County and Jennifer Drake. Those are the two people right now that, oh fucking A, man, that I do not want to be. Holy shit. Oh God, here we go. Jennifer Drake's. God answered our prayers. We have answers. There is a saying or a rule. There is always two sides to every story. But then there is always an exception to every rule. And this story is the exception to that rule. There is no other side of the story. This senselessness is just that. Senseless, period. Am I mad? Yes, extremely. I have had my yelling match with the Lord. I know my God is big enough to handle it. I know you fucking. I am fighting to wrap my head around these answers. The humanity of my visceral response is trying to reconcile with the deep knowledge of God's faithfulness and love. Excuse me? What the fuck are you even saying? On one side, I have such heavy grief flooding in again, and then on the other, such intense gratefulness. I weep deeply with the reality of this evil. Oh my God, are you talking to yourself, woman? Guys, this is her post. So, is my faith crumbling? No. He is still the Lord of my life, my rock in the midst of the storm. He has answered our prayers to bring this evil to light. I am thankful the authorities working on this case looked at my sons and daughter and said, "Your father was a very honorable man." I am thankful to my core for the hard work, sleepless nights, and endless tenacity that the law enforcement has given to this case. I am forever grateful. They all continue to be in my prayers. This story is not over. It may be a long road, but we are up for it. We will pray and fight for justice. Hashtag justice for Brian Drake. That's what she posted on August 31st, 2020, after the arrest of Dan Moore. She declined to have a press conference. Jennifer, you make me sick. You're a fucking liar. But more importantly, you are diabolical. Every day you live a lie. And you know what? People that truly know you know it. I think your sisters know it. I think your sisters do know it. Okay, let's see the responses here. Jen, to see you personally experiencing this deep pain is unfathomable. I love you so very much and am with you in prayer every step of this forward journey. Chrissy says, love you. Tara says, my heart goes out to you and your family finally answers prayers. I don't know what the fuck answers you got from that mumbling, bumbling bullshit, but I didn't get any answers from that. I saw they found the man, says Jennifer. I am so glad for your family for this piece of information, and you continue to be in my thoughts. I wonder if she's in your bed. Jim, I read the article in the paper. I knew it was a good thing, but would still be very difficult and wouldn't help with the pain. Emily says, Jennifer, we will pray every day that true justice will be served against this true evil that has befallen the family. Okay, Emily. Nice fucking interview with the police. Emily. Marla says, praying and praying. Hope says, I was just talking to my parents about this weekend, and we prayed for answers. Praise God for answered prayers. Love you so much, and I'm continuously praying for you and your kiddos. Bethany, dear heart, I battle for you in prayer before the Lord, as I know so many others do. No words. Pain so deep we cannot even try to understand. By faith we proclaim God is good and he is able. By faith, beauty from ashes. By faith, what the fuck? Oh. Kara Wimmy, what's up? Continue prayers for wisdom and strength to seek justice. We are rooting for justice in the midst of this evilness. My God. Unfucking believable, these people. All in his timing. Thank you, Jesus, for answered prayers. I'll double up on my prayers. I knew he was a good man. I'm glad the world has proof of that. And you have answers to your prayer for closure? I'm so sorry your heart is breaking again, but it's another step in your path to heaven. Oh my fucking God! Catherine! I knew he was a good man. For fuck's sake. Oh, Jennifer, answers are good, but they do open our hearts to new pain and questions. I'm so grateful to see you leaning into Christ. Even as you process this new information and cry out in grief, you and your children are in my prayers. Comfort, justice, peace, and even joy and sorrow to you. Joy to the world. All the boys and girls. Oh my God, we love you, Brian Jennifer Drake. Oh my God. She's such a whack job. Exceptionally cowardly. A fine young father recovering from 2 major surgeries, back and leg, and a coward who would never stand at a face-to-face meeting with a gentleman who would extend his hand in friendship. Excuse me? Jen, you are the rock. Your faith is strong when most would turn their backs and ask why. We as humans can never understand the evil that others do and why. Onward, Christian soldiers. Oh my God. Jesus Christ above, please. You and your family have handled this senseless tragedy with grace. Your faith and honor is beyond words. My God. We love you dearly. As a side note, I am very angry and struggling to wrap my head around all of this. Yeah, it was pretty hard to wrap around, right, Linda? It's like unbelievable, right? Yeah, because it is unbelievable. Fucking A. Everybody in the world was asked in this interview, well, if you had to say anything, what was the first thing that came to mind? Oh my God, that Brian was cheating and he got caught and he got shot. Not a single one said a chiropractor did this, just so you know. Oh my God. Here's Brian's family. Kathy and I share your thankfulness for this accomplishment in the case. And we also share the horrific pain and anger against this cowardly murderer. Can I please talk to these people? Regardless of what his friends and patients say, he is a cowardly murderer who robbed his family of a beloved husband, father, son, brother, and friend. What about, why aren't you talking about your son being robbed of his life? Jen, you are the rock. Kathy, exceptionally cowardly. A fine young father recovering from 2 major surgeries, back and leg, and a coward who would never stand at a face-to-face meeting with a gentleman who would extend his hand in friendship. That's perfectly said, Miss Drake. And you actually said it to the right person. Unreal. I know people probably were like, what the fuck? They weren't like... Unreal. Emily! What's up, Em? We love you and stand with you through this journey, my friend. Yeah. Mm-hmm. Where's Amber Van Lang? Where's Amber Van Lang? Come on. She's got to be on here. Jennifer, there are truly no words. I have read about this monster that murdered your husband, and I cannot imagine your new... Steve and I are praying for you and your beautiful children, but it seems so little in light of this development. I'm sure it brings you a somewhat sense of relief, but also a lot of anger and a sense of what is the worst life has to offer. Your continued faith is what is bringing us all through this unbelievable, senseless murder. I love you and pray for you always. You guys are fucking praying and loving a fucking murderer. Awesome. Where is Amber Van Lang? Come on, girl. Yes, my friend Brian was an honorable man. Thank you, Lord, for answered prayer. Hurting and praying for you, Brian, Jennifer Drake, and your children. Always your friends, Lowell, for the Gravers. Well, that's interesting. Let me just double check. Hunter, I love you and your family very much. Brian was extremely honorable, and his legacy is deeply rooted in your incredible family. Interesting. Where's Stephen Minert? Where's Logan? Where's Stephen Minert, Logan? Where's Cheryl, Josh, Amber Van Lang, Spencer Van Lang? Where are these people at? They're not here, are they? Interesting. Very interesting. Jen must be eating all the attention up. I'm surprised she hasn't taken a one plane ticket to Vietnam, man. Vietnam? Don't they have no extra, like she can just go there, right? They can't extradite her. Unreal. Oh my God. A bunch of weirdos. Dr. Moore was getting death threats? We know of a widow with 4 kids who will have another sad Christmas. Thanks to you, ... killer. Yours affectionately, the Watchers, now with wireless cameras. What the fuck? Moore, acquitted, ? Sure, we knew you would be with your friends giving you your free to walk papers. A tragedy and a travesty of justice. Hopefully you will get your dues. It is a small town. You earned some shit coming your way, Killer Moore. Not everyone in town is your friend. Not everyone believes your lies. Many of us know you are guilty. Karma is a mean little bastard. It was mailed out of Spokane. We are keeping track of you, murderer. watching for us in your rear view mirror, murderer. We will see you at Safeway very soon, murderer. How well will you sleep at night while we watch you? Bear in mind, we watch you each day. Killer, 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 killer. Affectionately, the Watchers. Dear Dr. Moore, although we Watchers have not been in touch for a while, we watch you every motion, every gesture on your smug face while you stand in line at Safeway. When shall we wreak what revenge, killer? The citizens of our little town know that acquittal does not mean innocence. Killer, killer, murder, killer, murder, killer, murder, killer, murder. In all due respect and love, the Watchers. This is so fucking sick. Oh my God, she denied saying that to the spokesman review. Jennifer Drake is 100% certain that Moore killed her husband. All right. Oh, fuck. Oh my God, Tatiana! Tatiana, where you at, girl? Tatiana says, I don't understand how a person can commit a crime and get away with that. Justice for Brian, and not only for him, but for his family. They have to live with this pain. They lost an incredible man. Tell us about that. Words can't even describe how wonderful and a blessing Brian has to many, many people. While this person who committed a crime is living his life perfectly after confessing that he committed murder. This is absolutely crazy, says Tatiana, and sickening to my stomach. I repeat, it's crazy, she says. Tatiana, can we please talk? Joanne says, I can't believe he is still adjusting. Did I read that correctly? Who'd still go to see him for care? Unbelievable that this man confessed and is back to work. Joanne says, I don't get it. How does he still have patients that want to see him for their care? No way. They probably don't know, she says. Blows my mind that in this day and age, his confession wasn't enough to keep him locked up. Got me locked up. Dr. Drake has a song named The Watcher on his Chronic 2000 album. Interesting, really? Brian Jennifer Drake. My God. PDF of the affidavit of probable cause for the search warrant. She had it saved more than once. This is so heartbreaking, says Karen Shively. I can't believe Moore is working. We will be praying for justice for Brian. Such a senseless crime. Well, if you want justice for Brian, then you might want to look at the facts. Go to all these people in town that don't do fucking dick all day. Go to the trial. Hear it for yourself. Tatiana, do you have an OnlyFans page? Let me know. I'll hit you up. Jen, this is crazy. I just read every word of the affidavit. I know. And it is public knowledge that the defense is trying to throw out the confession in court. Oh, geez. How could they throw out something that was confessed and recorded? I read every word as well. I'm angry and sad. Throwing out a confession is total BS. Brian, Jennifer Drake, I'm sending you all. You know what Brian probably did in his grave? He's still probably just rolling in it, man. I'm sending you all the light, love, and good vibrations. Good vibrations that just, what the fuck? This is Tina with What the Fuck Transition Services. What the fuck does that mean? I'm sending you all the light, love, and good vibrations that justice will prevail. What the hell does that even mean? Cried all the way through and gasping at parts. My heart aches for you. Oh my God, Tatiana. I wonder what all these people are. You are so loved, says Monica. And as you can see, you have hundreds by your side ready to help. Good. Let's see if people show up for court. Make sure you guys come out. We'll be tailgating. If you guys want a shirt, let me know. We have some shirts that says Satan coming through the floorboards. And you can, if you want to put a head of Moore on there, I'll give you the Moore or the Jen logo, whichever head you want. If you want to put both side by side, we can make that happen too. Dear Jennifer, dearest Jennifer, I read the entire affidavit. And firstly, congratulations to the police officers in your area on their investigation skills. Fuck. Secondly, I am praying hard, God, yes, that they pursue justice in this case. It seems pretty cut and dry to me, but I know how these things work. So I'll be praying that God has his hand in this case. I've been praying too. And that the outcome gives you and your family some sort of closure. Lana, I wish you would say, dear Jennifer, I read the entire affidavit. Alpha David. I'm without words, Jennifer. Jennifer, can you go ahead and DoorDash me some more Twisted Tea? Heather C says, I feel so bad for the Moore family. I hope they sue the hell out of everyone they possibly can. Right? Right? I mean, how people literally I know everybody watches this channel in that town. Trust me, I get so many emails. I know about it. Why do you think there's 126 people still watching? Bonner's Ferry is this big, and they're probably all on Bonner's Ferry right now. And they're like, God, she's right. Jennifer has to record all of this stuff, and then she probably gives it to her lawyer, and then that's probably $400 per hour. So this will probably set you back about $1,600, unless he's doing it pro bono. I am baffled that Moore is practicing. Have you reported him to the chiropractic board? I will be praying for God's hand in this case and with your family. Fuck you, Lily. Have you reported Moore? For what? Report him for what? Report him for what, you fool? Report him for what? Little tattletales. Like, listen. Eee! Jennifer Drake called Brian Drake Adonis. Okay, that's what she had him saved in his phone as, Adonis. Like, what the fuck? Brian Drake ran from you. Brian Drake locked you out of his phone. Jennifer says, important update. This case is now going to the Idaho Supreme Court. The Idaho Attorney General's office filed the notice of appeal in State versus Dan Moore this past Wednesday, the 19th. Well, I wonder how the Attorney General is going to feel when he gets my 300 and now it's up to 71 page report. I'm extremely grateful for Tevis. Tevis is dead. Tevis Hall's dead. I'm extremely grateful for Tevis. You guys just on his full first name? Tevis. The state prosecutor on this case, Tevis Hall. She says, I'm extremely grateful for Tevis. Doesn't say like Mr. Hall, Tevis. The state prosecutor on this case thus far. He has been stellar, she says. Why? Because he lets you get on the stand and say, I called the police. And then they knew that you didn't. For my cell phone. I was at my home with my daughter. She's already tripped up, said two different things. She's fucked. And now he passed it into the hands of the higher courts. I have had to remind myself that this is not a cold case. It's not. If, but when, and that when may take a few years. My faith and my backbone continue to grow just as much as my nose. As my belief that within what? My faith and my backbone and my nose continue to grow just as much as my belief that even when humans, media, and justice system fail us, my God does not. I fucking know. God was like, Lana, you're going to find this case and you're going to go help these people. And by God, you're right, because my God and your God are the same God. I'm a Catholic Christian person, and guess what, Jennifer? You are far from anything what is godly. You're sick. And these people that are around you, they know that you're fucking... Dude, I did a fucking poll, and people think that you are more dangerous than the woman that is in prison facing conspiracy to commit murder against her husband, Jared Bridegan, Shanna Gardner. I said, who do you think is more dangerous, Shanna Gardner or Jennifer Drake? And do you want to know what the census was? Like across the board? It was all Jennifer Drake's. I have to agree with them. But my God does not. I ultimately must trust in God's justice. I often succumb to the rolling human emotions associated with the devastating news, the dismissal, but it's shortly thereafter that I press in to seek the internal perspective above all else, which is what? Thank you so much for all of your encouraging words and unfailing prayers. Pray for the men and women presiding over this case. Well, Tevis Hall died. For their hearts to be full of wisdom and discernment. His timing is perfect. Hashtag, his timing is perfect. Girl, you are whack as fuck. You're absolutely fucking out of your mind. Brian's murderer has chosen to take us through a nightmare for the last 2 years, but I am confident that the truth will prevail. Thank God it took that long, because my God has this covered, she says. Job 12:22. He uncovers deep things out of darkness and brings the shadow of death to light. I got some for you, John. Let me give you my favorite piece from the Bible. It's Romans 12:19. Beloved, never avenge yourselves, but leave it to the wrath of God, for it is written, vengeance is mine, I'll repay, says the Lord. The verse continues, instead, if your enemies are hungry, feed them. If they are thirsty, give them something to drink. In doing this, you will heap burning coals of shame on their heads. Take that. Like Biggie says, take that, take that, take that. Jennifer, you looked hungry, so I fed you the truth, girl. Oh my God. Dear Brian, my dearest husband was murdered 2 years ago today. The ripple effect of the depravity of another man's free has had major consequences on our personal lives. My faith has been tested like never before and continues to be. So today is a day of much reflection, and I choose to reflect with gratitude that I'm not in prison. I'm grateful for 22 years together with the love of my life. The children and I are grateful for all that Brian sowed into us and others as we laugh over great memories. We are grateful how loving God has been to us as he walks us through his journey. We are not worthy, but he has blessed us deeply. My children are healthy and thankful. They have amazing people who pour into their lives on a regular basis. We look for God winks in our lives every day, and he shows up every single day. We have learned much about the depth of his goodness and how it is possible to praise him in all of the hard. It was a cliche until it became a hard reality to be tested. We still fight hard after justice. We are waiting for a date to be rescheduled on the calendar of the Idaho Supreme Court. However, our faith and trust still does not waver in accordance to the outcome of this never-ending trial and looming lack thereof. This is not a cold case. Cold cuts. Give me my cold cuts. We know who murdered Brian, and we still wait patiently for God's hand to move. All right, guys, you guys take care. She is delusional. Okay, this broad is cuckoo for Cocoa Puffs. All right. We are pleading and believing for it to end. If you want it to end, why the fuck did you do it? We ask you all to continue to contend on Brian's behalf. But no matter what, God is still good. At the end of Brian's funeral, my dear friend Emily, oh my God, Emily Roadwall, sang the song Goodness of God. I wanted to declare that I still believe he is good in the midst of such grief. All my life, you have been faithful. In all my life, you have been so, so good. I have a song for you, Jennifer. I got another one for you. What's today's date? What's today's date up in here? All my life.